There and taps his hands and you're just sitting there and he, sits there and rocks back and forth in the chair like in a bit of another murderer or whatever he is convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other or both, and in orange.
Hello everybody, Excited Utterance here. My name's Hella and we have another big stream today, all focused on Bryan Kohberger and the case against Bryan Kohberger, Idaho versus Kohberger, and a nasty topic, bit of an ugly topic, the death penalty. Welcome everybody, I have a fantastic guest for you. I'm going to say a few hellos first. Welcome in, and we are dual streaming as well over to Steve Gosney's channel and his Rumble as well. Hello, Fiery Red. Oh, I'll leave that one for Steve to say hello to. But hello in advance. Half Irish. How's it going, my good friend? Hello. Ilya Talk. Hey. How are you? How are you? Hey, Justin Smith. Hello. Welcome in, guys. Danielle, good to see you. Melissa, you set your alarm about 3 days ago for this one. Good to have you here. Saltwater Soul, hello. Hello. And Tianina is here. Good to see you. Factual Lie, welcome. And Forensic Furor, okay, my friend. Wow, we've been through a fair bit over the last few months, haven't we? And Andrea actually did state she was, when I told her about this stream, she was like, "I'd love to pop on," and then she said, "Oh, but I'm cornering or something and boxing. What do you do? Like, do you have something in a corner boxing something?" And I was like, it's cool. I was like, I didn't expect you to come on, but she was like, I'm really interested in it. I'll watch it afterwards. Okay, cool. Lovely. Miss Potage, lovely to see you. And Rachel, hi, Diane. Hello. Alrighty, let's go. Nick, my mate, my Viking mate. Good to see ya. Alrighty, now it is time to introduce my guest, Steve Gosney in the house. Can we hear you?
Hi. Can you hear me? Hello. Is this thing on? Good to see you, man. Yes, and I really thank you for having me on. This is an exciting little tidbit of topic for me. I gotta say, you waved this flag like, ooh, this is my kind of thing. So you invited me on, and I thank you. You and Nick Starro have been so kind to me in the last few months, and I thought, what better place to be than Excited Utterance, and here I am.
And look, Nick's gone and gifted 10 Excited Utterance membership. What a legend, Nick. Thank you. That's so nice of you. If you don't know who Nick Starro is, he has a fantastic channel. He is covering the Young Thug case, or the RICO case out of Georgia, Atlanta. Has been right from the beginning. It would be great if one of the mods please could put his link up there. Thank you so much for your generosity today, Nick. and for being here. Right, so I need to introduce my lovely guest, but first, you want to say hello to Fiery? Fiery was first
Yes,
in
Fiery
chat.
Red Padcast is here, and he's one of my buddies. And I'll tell you, he's been suffering and he's been fighting cancer. And I had a stream on my Rumble channel with him, and it was really inspirational to me. And I will say that his suffering, puts things in context for you, because when I was suffering, Fiery was out there supporting me. And I really am, he's a blessing, and he's out there, and I'm glad he's still in the chat fighting away. And I just wanted to give a special shout out to him. I see I've got a number of friends like Shane Sousa's out there, and Bella the Bayou, and Upon the Horizon, good people still hanging out. So and obviously Danielle, my super friend here, and
You have
all
lots of people who love you,
kinds of
Steve.
good people. So I wanted to thank you all. But today we've got a very serious and in-depth. I know, isn't that sweet? And those people, the friendship that's out there has been so nice. Oh, and Andrew Branca's here. He's been great. And you and Nick Starro too.
Hello, Andrew.
So God bless you.
Andrew's here somewhere, is he? Where? I gave him a wrench so I could see him.
He's on the road. He's in his motorcycle.
Oh, there he is.
riding
Sup?
around. Yeah.
Sup, Andrew? How's it going? Another great lawyer that we have on regularly when he's not on a motorbike.
Lee's out. You see this? It's like the old folks here. They're back. It's like coming home again. Lily, Michael, Stetson, all these people.
It's good, isn't it? It's lovely. So for those who don't know, Steve has had a little break from streaming. So obviously, when you come back and all your people who love seeing you so much are so happy to see Steve back again. Now, Steve, there's a lot of people here who don't know you. So if you wouldn't mind giving us a little bit of a, intro.
Well, it's a big process. But, well, let's talk about my intro for this. Okay, so I've done death penalty appeals, so I'm death penalty qualified to do death penalty appeals in Florida. I'm board certified criminal trial. I've also been trained on capital jury selection, which is specialized in the public defender's office. I was a public defender appellate lawyer for many years. I assisted one of our capital trial teams when I was in the public defender's office. I've written 3 books on the death penalty. The first one is a crime novel that involves a death penalty case. And the idea for that was to provide a factual understanding of a death penalty case from the crime to the investigation to a trial to consequence. So that's the arc. That's the criminal arc. It has been misconstrued by the anti-truth legacy media as being a sex novel, misogynistic sex novel. But in fact, that is the villains in the case are evil prosecutors who are misusing their power in a way to convict an innocent person. So, but that book is actually the first book in a 3-book series. The second book that one's called Death Penalty Desired, Passion and Murder. And it's to give you a factual framework so that you understand what a death penalty case is involved, and so that you have a framework for understanding, like a fact pattern. The second book is called Death Penalty Debates. And Death Penalty Debates is an even-handed approach to the public policy question of the death penalty. So what I did is I just listened for a couple years to everybody's arguments and summarized them, pro and con, about the death penalty, and laid them out in a scale so that you can make the decision for yourself and weigh the different factors for yourself. That's called Death Penalty Debates. And then I have a third book out, which is my latest book, called Death Penalty Designs, Maximum Due Process. Designs. And that one is more of a legal attack on Florida's death penalty, to understand the constitutional problems with the death penalty as it is currently written. So, and that's this one here, Death Penalty Designs, Maximum Due Process. And actually, that is the book that we're going to be talking about today, which is my latest one. And it's kind of a summary. The idea here, these 3 books work together to train capital appellate lawyers in Florida, because there's no framework for training people. So, but you can pick and choose. Like If you're interested in the true crime stuff, you got the first novel. The second one, if you're interested in the public policy debate, but this is the law as it applies to the death penalty. Now, this is in Florida, but it's nationwide. The book is basically federal law, so it will apply in the same context. I recognize these motions that are being filed in the Kohberger case because they are the same motions we file in Florida. All right.
Yes. And when I showed you the motions, you actually got a little bit like a kid in a candy store, kind of excited because you're like, chapter 9 is that one, and oh look, there's the HAC thing, that's all brand new stuff. You're like, and I don't know if I'm not quoting you, but the thing about it is, when you know how sometimes you see like the forensics people in a trial, and maybe it's a paleontologist or something like that, and they get super excited about their field of study, and you're like, wow, this person really, really loves bones, like that. Steve really loves death penalty, constitutional law when it comes down to it, don't you? Like, you really know you really know.
Like it. I mean, I don't like it. It's an esoteric bit of law. It's very complex. It's kind of the mountaintop of criminal law. So when you deal into death, when you're dealing with criminal law, misdemeanors are easy, even felonies are easy. When you start talking constitutional law and the death penalty, it gets very complex. So and I think I have a little bit of a talent of explaining complex subjects simply, but it's very hard to do in this topic. So I'm going to try to do that with these Kohberger motions. And I want people to listen if they're interested in the law as it applies to the death penalty. We will go through that and explain why the death penalty may be unconstitutional in these particular circumstances. Now, the first thing we need to understand when we're talking about Bryan Kohberger is that this set of motions that were just filed, the ones that we're going to talk about today, are not Kohberger specific. So they're generalized attacks on the death penalty as implemented in Idaho. And they are federal attacks. And so they're saying, regardless of whether Bryan Kohberger is guilty or not guilty or did it or didn't do it or anything like that, the death penalty itself, as instituted in Idaho, is unconstitutional based on these reasons. And each motion lays out a specific reason why. And I recognize those reasons because those reasons also exist in Florida, and they are based on federal constitutional law, federal Supreme Court precedent. All right. So when we go through these, if you want to get into the weeds about whether Kohberger did it or he's guilty and the evidence and all, that's something Andrea Burkhardt is right on top of. She's the go-to person on this. To me, she is there. She knows what's going on. She's been in the evidence. She's been following it. She's doing a great job, and she's a brilliant defense lawyer. When you want to talk about, but that's not what's going on here. Okay, what's going on here, and the things we're going to talk about today are the set of motions that are saying the death penalty as it's instituted are unconstitutional because of this reason, right?
Cool. Just your internet's breaking up a little bit. So you're having some freezing moments there, like Elsa.
Let me fix something. Hold on a second. Let me try this.
Cool. And I'm just going to introduce Darlie
Is that better?
Ilya. Hey, how are you? Yeah, that is a bit better. Awesome. Hey, Darlie, how are you?
Sorry about what did you miss there? That was all the most important stuff, you see.
No, you were okay. We heard it all. You were just like
buffering a couple times. Audio was okay.
Doing a bit of buffering, but apart from that, we heard it all. It was fine. So, how are you, Ilya?
So the issue, hey, good to see you. Good man. We're just getting into the weeds here.
Yes.
Yeah. Sorry.
So I don't weigh in. I don't have an opinion on whether he's guilty or not. To me, I understood, and remember, I got kind of memed a little bit because I got real excited when I said that they found DNA on the snap of the K-bar sheath that was under one of the bodies, and it was his DNA. That is deadly evidence if that's true. To me, that is just really hard evidence. Now, whether or not, I don't know, but the other one is there's actually a witness, if you remember, who saw a figure who will be matching his description, and then there's cell phone evidence about him going around, and then he left his cell phone. I don't know. I'm just. This is all.
I know.
Well, you've been You've been listening to Dateline or something like
No,
that.
this is when it first came out. That's what
Yes.
I heard.
I think he just hasn't really heard the latest updates, is what's going on.
I haven't, but I don't
he
have
hasn't
an
been
opinion.
deep diving into it, and that's
No.
fair. That's fair.
It doesn't matter. It doesn't matter because the death penalty in Idaho, whether it's constitutional or not, is independent of his guilt or innocence, or guilt or not guilt.
What I wanted to ask is, okay, like you've answered my question, but I need to ask it anyway. And that is, you said that those motions that were put forth are they're not Bryan Kohberger specific. They are general. They're death penalty. They're about the death penalty in Idaho. So why is that the case? Like when I first read those death penalty motions, that was my issue with them. I'm like, these don't hit the mark. They're not about Bryan Kohberger.
Yes,
They're
they aren't.
just
That's-
about the death penalty. So who are
Exactly.
they to be arguing in this trial court about the death
Well-
penalty in Idaho? What good's that going to do them?
Because if he is convicted, there will be a mandatory appeal. And in order to appeal these issues, to raise constitutional objections to the death penalty, you have to preserve them below. So there are a number of problems with the death penalty statute, like for instance in Florida, that exist in every death penalty case. So in every death penalty case, you're going to file a bank of motions challenging the death penalty, so that if the person is convicted and sentenced to death, you can then raise them on appeal, and they have been preserved because they've been raised below.
Okay, so you're saying that they worked very, very hard to write all those motions and submit them on the deadline because and the magic word is if, he's convicted and receives the death penalty at appellate stage, they will need those things to be in the record.
Exactly.
Right.
Exactly.
Okay.
Yeah, because he can say it was waived. He didn't raise that below, and so it's waived. So and that's the thing in any death penalty case. And I imagine from what I understand, the Idaho death penalty hasn't been used in like 10 years. So there's nobody around that knows how to implement, knows how to do it. I expect, I don't know, but I expect that this death penalty defense attorney has shopped around, talked to various other states, like in Colorado, maybe, or maybe in Florida, or maybe Texas, and has gotten the motion bank from them and used those motions in this case to say, okay, here's problems with the Idaho's death penalty, and I'm going to make them individually, each motion laid out. And we'll go through some of these motions to explain exactly, because they may be nitpicky, but they're problematic from a constitutional standpoint. It has nothing to do with Kohberger. It has everything to do with the death penalty. Is it constitutional in Idaho the way it's implemented?
Absolutely. All right. So I wanted to just quote something from your book, and it's brand new. And if you're interested, it's linked up at the top of chat. But also, mods, if you wouldn't mind just including into chat every now and again the website. So Steve's website, there's so many great titles there, especially about the death penalty, some that are really thought-provoking. So if you haven't noticed, Steve is anti-death penalty, even though he's had chosen a career where it's a topic of choice, I suppose. Something we had to deal with it every day.
Yeah.
You know, I was 60-40 for the death penalty before I became a public defender. I mean, and I also before I became a Catholic. So I have religious objections, and which are laid out in death penalty debates. But then I also have practical objections, which are laid out in death penalty debates. So I'm religiously opposed, but if I was not religiously opposed, I would still be against it, because I think the negatives outweigh the positives.
Yeah.
Permaseal Finishing, did you get that super chat? Is that on my super chat?
That's yours. Okay, so where is it? Oh, hang on. There we go.
Gosh, missed you. Thank you. See there, all
that's
the
very
love. Thank you
nice.
very much. Permaseal Finishing
Lovely.
for all your finishing needs.
For your finishing needs. And Benjamin, streams with Steve Gosney are always fun. Yes, they are, definitely. And thank you for being a member for 9 months. 9 months. That's lovely. And Nick also a member for 9 months. Let's make the chat green. Yes. As much green as we can have. Okay, so I pulled this out from your book because it really resonated with me. Death is different. It's a different punishment to any other punishment that can be given to a defendant. Obviously, there's nothing that quite.
Well, let's talk about death is different. All right, because people say, oh, that's just a slogan. All right, but let's talk a little bit before we kind of get into the weeds. Now, there was a case called Furman v. Georgia in 1972 that struck down the death penalty across the country. Now, people say, well, that was a spasm of left-wing activist court rulemaking, right? And baby boomer 60s era kind of progressivism, and it's so garbage. But if you read that case, it's a very complex case to read, I will say. But understand that that's kind of the marker. You need to say that is the marker of modern death penalty jurisprudence. And that case, which is 1972, United States Supreme Court, there's a bunch of opinions. The majority said, they're all for different reasons and different opinions. Complex case. But the reason that people agreed on was that it was unnecessary, that it was arbitrary. Yes. That it was arbitrary. That's the key word that you need to understand. Because the death penalty was arbitrary, it is unconstitutional. What that means is it strikes like lightning out of the sky, and there's no rational basis. Law has to be rational. Now, the modern era people don't understand that, but common law there's supposed to be an underlying basis of reason and rationality. And if you don't have that, it is arbitrary and therefore unconstitutional. And that is what they found, that the death penalty was arbitrary. So the solution, then what happened was the legislatures came together and they said, we still want the death penalty. How are we going to make it less arbitrary? And then so in 1976, Georgia had re-implemented a death penalty statute and incorporated several features that made it less arbitrary. And one of those things was we have statutory aggravators. So we have to list the reasons why it's set. So here, let's back up again. I'm sorry, this is complex, but let me explain.
So nobody judges what is heinous.
Right. Well, wait a second. You're jumping ahead. Okay, don't jump ahead. Let's just talk about it just conceptually. The death penalty can't be arbitrary. The Georgia solution to make it less arbitrary was to say, all right, we have a bunch of first-degree murder cases. Some are entitled to the death penalty and some are not. We have to distinguish between which ones are the most heinous and which ones are just general first-degree murder. All right, well, how do we do that? Heinous. Yeah, just a little bit. So what we do is we say, okay, we're going to create a list of statutory aggravators that, if proven, make this different from the rest of the first-degree murder. For example, I would say the easiest aggravator, if you had one aggravator, the one aggravator I would say would be a smart aggravator would be multiple homicides. Because you could say, how do you distinguish regular first-degree murder from death penalty qualified first-degree murder? Well, multiple victims. So regular first-degree murder, one victim. If you got two victims, eligible for the death penalty. All right, so let's just say one aggravator, and that would be it. Does that make sense?
Yes.
And that makes it less arbitrary because I can distinguish. Now I can say which one's eligible for the death penalty, the one with multiple victims. Yes. All right, so another thing, there's two other features of Georgia's death penalty at the time, and that they said in Gregg in 1970. Gregg was the re-implementation. They said it's less arbitrary because it has aggravators. It's less arbitrary because they bifurcate the trial from a penalty phase from a guilt phase. And it's less arbitrary because there's mandatory Supreme Court review in Georgia. So if somebody's sentenced to death, there's mandatory Supreme Court review by the Georgia Supreme Court. All right. And those three things made it constitutional. And then everybody copied Georgia's statute. Okay, so that's the framework you got to understand. Now, death is different. What you've got up there is a quotation out of Gregg v. Georgia. That is a quote from the United States Supreme Court in re-allowing the death penalty in certain cases when there are certain constitutional protections provided for. All right, so enough. So this is your lesson. So I'll stop there and we can move forward.
Yeah, well, and it's the title, it's a chapter in your book, and I read it, and I wanted to pull it out. And also, this quote from Clint Eastwood, like, that you put in, as Clint Eastwood in the movie Unforgiven coldly stated, "Oh, Darlie, would you like to read this?"
It's a hell of a thing, killing a man. Take away all he's got and all he's ever gonna have.
It's quite good. It's not
Oh,
bad.
well, actually, Death is Different is from Atkins v. Virginia, 2002. Sorry, I'm getting my quotations mixed up here.
Make sure
Maybe it
you
was
got
in
it
both.
right, but I'm pretty sure that's the right movie, though.
Yes. This is Clint. I love Unforgiven is one of my favorite movies, and
Yep.
I think it's a great movie. And that is, I mean, death is different. There is something innately different about death penalty, and that is that it is, if somebody is found actually innocent later, you can't undo it.
My
And
bad.
so
No
it's
going
just
back.
basically it's irreversible.
Cool. So, what did you want to look at first?
Well, and let me explain another thing. So when we're dealing with death, there's another concept you have to understand. So the first is this idea of aggravators, and the aggravators
Yes.
have to be specifically listed and disclosed. And like I said, to me, a good aggravator system would be one aggravator, and that would be multiple victims,
Yep.
because that would be easy to distinguish. I can see, and also it would provide an extra deterrent, because I always think about The Sopranos. You remember there was this guy, I think it was Johnny Sack, and he's in the hospital, and his doctor is he's a guy that had killed somebody, and he's talking to him. He's like, well, he killed his wife or something. He's cleaning up the body, and then the postman showed up, and he killed the postman. He's like, well, at that point I was committed, right? So he's like, but it's like, I always think about it, he might as well kill the next guy. So that's the thing. I mean, but if there's a death penalty for the additional murder and life only for a single murder, then I think that maybe there's a deterrent effect for the homicide. All right. But now what happens is legislatures aren't happy with the one aggravator, because what happens is somebody, there's Marcy, or there's Michelle. Michelle gets murdered, and she's a little girl, and she's buried and killed in a heinous way. So then there's the Justice for Michelle Act, and they add as an aggravator, well, a young kid, or a torture killing, or a this or that or that, a cop, and then an old person, and this. And so we start adding aggravators over time. So we start with the one aggravator case, which is easily distinguishable, and we start adding aggravators to it until we get such an extensive list that every case it applies. The death penalty applies, and then you're back to arbitrary, because you can't distinguish between the homicide, the first degree murders that apply and the first degrees that don't apply. And now if everyone applies, you can't distinguish, and therefore it's unconstitutional because it's arbitrary. Does that make sense?
It does. And so I have a question. In the case of Bryan Kohberger, they've continued with this charge of burglary on top of the 4 homicides. Do you think that is so that they can add an aggravator?
Well, it depends. I don't know the entire list on Idaho, and I picked out 4 or 5 of the motions we can look at, because I'm familiar with those attacks. I'm familiar with what those aggravators are. But you need to understand the framework by which we're attacking this death penalty, because what we got to do is we got to look at this and say, is this aggravator constitutional? And the hack aggravator is the one that is one of the worst. And that is because the hack aggravator.
So
Let's talk about
the
that
hack aggravator.
Yeah, and there's a motion. There's a motion saying the death penalty is unconstitutional in Kohberger based on the hack aggravator. They've applied the hack aggravator. Now, hack, I call it EHAC, which is especially heinous, atrocious, and cruel. So in this case, you have to say, remember, the concept here is you have a set of first degree murders. Some of them with death penalty, you have to be able to distinguish between some of the first degree murders that are eligible for the death penalty and those that are not. If I have an aggravator that applies to every first degree murder, then you can't distinguish, and therefore it is arbitrary, and therefore it's unconstitutional. Does this make sense?
Absolutely.
Hack,
Absolutely.
when you say, okay, something has to be especially heinous, atrocious, and cruel, that applies to every first degree murder. first degree murder by
which
its
one's
nature.
less heinous?
Yeah, it's like, okay, and so you killed the guy. I had a case, I argued this, in fact, it was the Colley case in Florida, where there was a murder and the hack aggravator was applied to a person who was shot in the back of the head and didn't even see it coming. And they said that was a especially heinous, atrocious, and cruel. Well, if you can shoot somebody in the back of the head without them even knowing it,
Yeah.
how much if hack applies to that case, it applies to every case, and therefore it's unconstitutional because you are not distinguishing. You have an aggravator that, if proven, applies to every case, so everyone is eligible for the death penalty. You don't distinguish. It's unconstitutional under U.S. Supreme Court case law.
Yep.
And that's what this motion is. So let's look at this is the hack aggravator saying that hack applies to everything. I haven't even read the motion. I know what's in it. Okay. This is what they're doing. They're preserving this issue for later appeal.
Yeah. So would you like Dali to read some?
Sure. He's the
Up to you.
professional reader. Right?
He's a professional reader.
Where would you like me to start?
Just from comes now, Bryan C. Kohberger.
Comes now, Bryan C. Kohberger, by and through his attorneys of record.
Sorry.
Here, don't
Hang on. There you go.
hereby moves this honorable court for an order striking from the state's notice pursuant to Idaho Code 18, 4004A, the allegation that the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. This motion is made on the grounds that this aggravator is unconstitutionally vague and fails to
narrow the class of
eligible candidates for death
or the death penalty.
partly.
That's right out of a Florida motion. We would see that in this motion would be filed in every Florida case.
Is it death partly or death penalty?
Death penalty.
Oh, look.
Oh, death
Aw.
partly.
They made a mistake.
Sorry, I had to point that out.
No. Well, it's interesting because people have been pointing out that there's a lot of copying and pasting going on here, and there's a lot of also spelling mistakes happening as well.
I mean, they kind of did bane
Well,
out
can I
several-
we'll jump up here? Mavka asked, has anyone won arguing this? Okay. Now that's an
was
interesting question. The judge denied, I'm sure the judge is going to deny all of these, right?
He has.
And the
done.
trial judge must deny all of these because they
Oh, that's interesting.
right, because the trial judge must deny them because the trial judge is not the one that can the trial judge is not going to stick their neck out. They have to follow Supreme Court precedent of Idaho, and appellate precedent is going to be that this is legal. So they're going to, as a matter of course, deny these motions. These are appellate arguments and arguments for the U.S. Supreme Court. Now, the person in your chat who said, has anyone won regarding this? Not yet. Okay. But however, this is an argument that is eventually going to win in the United States Supreme Court. All right. So not yet.
No.
And actually, I will say EHAC, and this is interesting because there is a chapter in death penalty designs on EHAC, and it has been struck down. EHAC has been struck down in some states.
Really?
Yes. Let me see. I'm going to get you the citations here. So go ahead and keep reading, and I'll find the citation.
Oh, yeah. Okay, cool.
Okay, so the U.S. Supreme Court has stated that the Eighth Amendment's prohibition against cruel and unusual punishment made applicable to the states through the 14th Amendment prohibits a state from imposing the DP in an arbitrary and capricious manner. Instead, the sentencing body must be provided with standards which will genuinely narrow the class of crimes and the persons against whom the DP is imposed.
And
Okay, so
there are
here's-
Case law.
Yeah, here's some case law here. Maynard, there's Gregg and Furman. We've talked about that. EHAC, Maynard v. Cartwright, 486 U.S. 356, 1988. The court reversed a death sentence because vague aggravators must be sufficiently narrow to avoid arbitrary imposition of the death penalty. Okay, so that is the basis that this aggravator does apply to every death penalty case, every first degree murder case, and therefore it's arbitrary. This is a winning argument, in my opinion, to to the U.S. Supreme Court at some time in the future. This is a very strong argument against the arbitrary application of the death penalty as it is written. EHAC should not be in any statutory death penalty enactment. They should eliminate EHAC as well as CCP aggravators because they apply to everything and it makes it arbitrary.
What's
If
the
people
CCP
were
aggravator?
cold, calculated, and premeditated, so that exists in every death penalty, every first-degree murder case. Now, so if somebody is pro-death penalty, because there's going to be people here like, I'm for the death penalty. If you're for the death penalty, then you should want death penalties to stick. You should want them not to be overturned in the future by a future Supreme Court of the United States. And if you are for the death penalty, you should be against the EHAC and CCP aggravators because they are built-in bombs that will overturn death penalties in the future by some future U.S. Supreme Court because they are arbitrary. As a matter of logic and fact, these are very weak aggravators that apply to everything. And if you're for the death penalty, you should want to eliminate them. But instead, people want to expand the death penalty. And so they want it to apply to everything. And therefore, they're making their statutes unconstitutional because of the political appeal. If you're for the death penalty, you should be against these aggravators.
That's very interesting. And isn't it so different to hear Steve saying in no uncertain terms that this is a winning argument and it's an argument for the future? I haven't heard any commentator say that at all. Everyone has been talking about how all of these motions were just denied by the judge and how the defense is messed up, etc. No one has given this point of view at all. And clearly it was... these have all been written based on a best practice that not even a best practice, a required practice.
Yeah. Okay, and this is one of the book is Death Penalty Design's maximum due process. Here's another concept. If you have a traffic ticket, it's like you're entitled to a hearing before a magistrate and pay the fine. If you have a misdemeanor, you're entitled to a little more protection. A felony, a lot of protection.
Yeah.
Death penalty, you're entitled to maximum protection, maximum due process. And so in that case, that's why a capital case is so advanced, because a capital practitioner, a death penalty defense attorney must file every possible motion. Okay, so a lot of these motions, they say there's difference, there's weakness, there's weaker ones and there's stronger ones, all right? To me, the CCP and the hack arguments are very, very strong. And in fact, that is the basis for future death penalty jurisprudence being overturned in the U.S. Supreme Court, is this very argument. Now, the trial judge ain't going to do it, and maybe the Idaho Supreme Court ain't going to do it. In fact, like when I was arguing this in the Florida Supreme Court's not going to touch this because they're all appointed with the litmus test to supporting the death penalty. The target audience for this motion is the U.S. Supreme Court.
Has to go all the way there.
Right. And here's what's going to happen, too. So, okay, it may not be Kohberger's case that's going to win it.
Yeah.
It's going to be somebody with a marginal case with a much better fact pattern. And then what's going to happen is then the Supreme Court's going to say anything with an EHAC aggravator is going to be struck down, and Kohberger's going to be in that group, and he's going to be entitled to resentencing.
That's how it works.
Yes.
Once the case law is established, then anyone can use it, right?
And see, as a death penalty critic, and I don't even, see, it's like I don't want to even help the death penalty people like to get the death penalty. But if you're for the death penalty, shouldn't you be for a strong bulletproof statute? But see, the politicians can't resist adding this stuff in.
Like DeSantis with his 8 out of 12 requirement.
Yeah, that's covered in the book too.
Okay, of course it is.
Because this is Florida. But Idaho, I don't think has that. Idaho has unanimity, right? So
I would hope.
Okay, so do you want to look at another one?
Yeah, let's look at the next one.
Sure. So motion to strike multiple victims. No. Motion to strike notice of intent to seek death penalty, failure to present aggravators,
Okay,
vagueness.
let's look at that. Let's look at the failure to present aggravators because that's interesting. I don't
Cool.
know what's in that one, and I'm interested because that's a little more case specific. But see, one of the things, like in Florida, they have to announce their aggravators way up front in a notice. Okay, and if they don't put those aggravators in, they are locked in by those. So the state has to list them specifically. They have to be statutorily authorized, and they're limited to just those aggravators. So let's see what this one says.
Okay, Mr. Dolly.
Comes now. Bryan C. Kohberger, buying through his attorneys of record, hereby moves to strike the state's notice pursuant to Idaho Code 19, etc., on the grounds that there was no check on the decision of the prosecutor to pursue the DP. The motion is based on the motion to strike notice of intent to seek the DP on grounds of failure to present aggravators to neutral fact finder.
I don't know what this one is. It's interesting. Let's go to the issue.
Okay. The Constitution requires a neutral fact finder to determine where the DP may be pursued. The process provided to Mr. Kohberger up to this point has failed to adequately protect him from being arbitrarily selected for the DP in violation of the 8th and 14th Amendments, in that no check was placed on the discretion of the prosecutor. The prosecutor has previously told this court what the state is trying to do is to enforce the law that our legislature has put in place that says, in cases such as this, in facts like these, a jury is entitled to decide not only guilt but potential penalty. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying, is wanting, is trying to kill someone is just simply appealing to raw emotion, and it has no place in this courtroom.
Oh, please.
Okay, I think what this one is, all right. There's an interesting argument here. I haven't read this full motion, but I'm going to opine on what it might be.
Sure.
And that is, it's arbitrary because of geographic location and application. All right. So again, remember that the pole star of a constitutional death penalty is that it be not arbitrary. Okay. So if you have basically just a jurisdictional problem, because most death penalties are applied in about 2% of jurisdictions in the entire United States. It's very county specific. So if you
Really?
commit a mass murder in a particular jurisdiction, doesn't that make it arbitrary? So there's a jurisdictionally arbitrary argument that's actually not a bad argument. That is, equal protection of the laws. If the thing that makes me eligible for the death penalty is that I happen to commit it in a certain county within the United States, and it's only 2% of the counties that are wagging the dog, the tail wagging the dog, right?
Yeah.
It's kind of an odd and arbitrary thing. So that they might be getting at that. They might also be going to the fact that nobody has been charged in Idaho until Kohberger. Now, Idaho is a very low crime state, and the fact that this is a multiple homicide and a very shocking one at that gives it. But the fact that the prosecutor is playing these emotional games and choosing which ones to pick and picked this one in the last 10 years to apply the death penalty makes it arbitrary. So that might be what they're getting at here.
Yeah, hang on. Let's see. Failure to present aggravators to neutral fact finder. So, hang on. Selecting candidates for death. Could you read this one, please, Dolly?
In Idaho, the decision to pursue the death penalty is the prosecutor's. 18-4004 provides the penalty for first-degree murder is death or life imprisonment, but it may only be death where the prosecutor files notice of their intent to pursue death. It provides the prosecutor may drop their pursuit of the death penalty at any time, and if they do so, death cannot be the outcome of a case.
Okay.
Keep going. This is interesting because, keep going here.
The only limitation on the prosecutor's ability to seek the DP then is that it to be a first-degree murder case, and that the prosecutor can find one circumstance of the case called an statutory aggravator, as explained in detail in Professor Cover's Narrowing Death Eligibility in Idaho. due to the broad and
Broad,
vague
vague
nature
nature.
of both what constitutes murder and what constitutes an aggravator, almost every
Every
murder
murder is
is
eligible.
eligible for the death penalty at law.
You see that there's a common theme here.
Yeah.
Okay, and see the common theme? And that is that, again, the concept that was announced in Gregg when they said, we're going to allow a death penalty, but in order for a death penalty to be constitutional, it cannot be arbitrary. And what that means is you have first-degree murders, and of those first-degree murders, you have to have aggravators that say, okay, based on this aggravator, this one is more eligible. This one's eligible for death penalty, and this one isn't. If you can't distinguish between first-degree murders, if all of them qualify, it is therefore arbitrary and unconstitutional. And that's what you're seeing. It's echoed in each one of these motions. It's going to be echoed, because when you say it, this is exactly what it is. You only need one aggravator, and if you've got an aggravator that applies to everything, there is no distinction. It's unconstitutional. You see, it's the same theme that's going to be echoed in each one of these.
Just got a question. So, Steve, you said if HSD was struck, Bryan would be resentenced. Isn't there a double jeopardy issue here?
No.
I'm a Brit, so I don't know too much.
No, there's not on that. That's complex. Double jeopardy is extremely complex, and there's multiple types of double jeopardy. But generally, you're entitled to a resentencing without that aggravator. Okay. But it could be that the death penalties were done. You don't know until the court actually announces what its remedy is. What you're doing is you are putting your marker here. You're saying this is unconstitutional, and if in the future that gets overturned, I want a resentencing. Okay, so
right.
Yeah.
Okay. And Fiery Red says, Stephen, thoughts on using it as a bargain chip to take it off the table for a guilty plea? I don't like using that to try to force a confession either.
Yeah, I agree. And that is covered in death penalty debates, the death penalty as a bargaining chip. And I'm not a fan of that idea, but it is there. And people, there's a pro death penalty argument, though, that is legitimate. And that is, if you take away the death penalty, life in prison becomes a new death penalty. And then that becomes the bargaining chip. So you're just lowering the bar one rung. So that is a decent pro death penalty argument. But anyways.
Yeah, I can't stand it. It's just like, okay, well, we'll kill you, or you can plead guilty.
Yeah.
It's like, that's
So he's citing studies here that's saying that basically every first-degree murder contains at least one aggravator. So every first-degree murder is eligible death penalty.
Yeah, you're taking a life. I'd consider that aggravating.
Absolutely.
Yeah.
That there is no jury entitlement to the death penalty. There is only the decision of the prosecutor that sets the defendant upon this path. The consequence of placing no check on the prosecutor's discretion to seek the death penalty is a system in which geography plays the largest role in determining whether the accused will possibly be executed.
Now, I will say I have not read any of these motions. Okay. So just to qualify, did I call it there? See, this is very standard. That is the geographical arbitrariness is a problem with the death penalty. Now, how good that argument is going to be up to the U.S. Supreme Court eventually. But there is a geographical arbitrariness to the death penalty.
Oh, there's a book being written on it too. So, The Geography of the Death Penalty and Its Ramifications by Robert J. Smith.
Yep.
Yeah. Okay, cool. Do you want to look at the next one? Okay. Multiple victims aggravator.
The multiple victim, that to me, that's the hardest one. Like I said, if you were a real death penalty proponent, I would make one aggravator and that would be it.
Really?
Because
I don't feel like that's like motion to strike that one.
That's one. I mean, it's almost pro forma. I'd rather not go into that one because to me, that's probably the strongest aggravator you could have.
I agree, and I am not a lawyer, but I look at that one and I'm like, maybe you need to put it down there.
As a death penalty practitioner, if you put in Florida, if you put a pile, like if you put 20 first-degree murder cases in front of me, I couldn't tell you which one and which is going to be death penalty or not. They're completely random. It's like lightning out of the sky. Now, if you had one aggravator and the one aggravator is multiple murders, it would be easy You could just say, okay, this one's got 2, this one's got 3 murders, and this one's got 1, so that's life in prison. That's the maximum penalty. But these have more than 1 murder involved, so therefore it's death penalty eligible. That would be very clean cut and very easy. 1 aggravator, multiple homicides.
We might just, I might just allow this question whilst we're between the different documents. So David Nolan, hello, welcome. Gosney question: can Richard Allen appeal? Receives new trial. Could new trial be a death penalty case again?
This is not Kohberger, and I am so out of touch. I've been working so hard.
That's okay.
I don't know what this case is, so I'm sorry.
Okay, so Richard Allen was just found guilty in Indiana of the murder of 2 little girls. He is appealing that decision. Could they now put the death penalty on the table even though they didn't try for it the first time? Is the question.
It depends on the state. I'm not sure. It's sort of out of context. Sorry.
That's fine. Yeah. Cool. And you have a new member, King Bob.
King Bob. Hey, King Bob.
Yeah. Cool.
Jacob Castro with his sub-savage. It's like that's like Jacob Castro comes.
Yeah, that's why we asked.
And Slidey Pie's here. Slidey Pie's here. Hi, Slidey Pie.
Slidey Pie is absolutely here. You could not expect Slidey Pie not to be here. Yeah, that's why I asked, because Rick Allen didn't have the DP. That's why. Okay, sweet. Let's keep going. So you want to... Okay, so the next one was... We decided not to look at multiple victims aggravator. So we have...
Well, let's look at that. Did we look at the hack aggravator? Did we actually read that, though? I don't know if you want to do that.
No. Did we or not? Hang on, let me see.
Oh, and the felony murder aggravator. We need that one, too, because that's an interesting one.
You're like, yeah, let's go.
I'll say this is fast, because I'm looking at these are the strongest. To me, these are the reasons that the death penalty will fail before the U.S. Supreme Court at some point in the future. These ones that I'm picking out, because like the felony murder aggravator, to me, that's a really strong motion. Now, again, the trial court's going to routinely deny it, but at the right case before the U.S. Supreme Court, this will be determined to be arbitrary, and the statute will be struck on these bases. And felony murder is a really good one, because well, go ahead and look at that one, felony murder aggravator.
Oh, sorry, you want me to change?
Whichever way you want to go.
Okay, sorry. Yep. We'll go with this one then. Felony murder aggravator. Okay. Yep. Are you in the mood to talk, Ilya?
Yeah. Sure.
Yeah.
Oh,
His name's now Ilya, by the way. Just, it's a thing. Off you go.
Okay. Bryan C. Kohberger, buying through his attorneys of record, and hereby moves to strike the felony murder aggravator from the state's notice pursuant to Idaho Code 4004A. This motion is made on the grounds that a malice aforethought murder cannot be aggravated by a burglary that itself is predicated on the same murder.
Okay, let's stop for a second and let me explain what felony murder is. All right, so felony murder is murder during the commission of an underlying felony. So in this case, he's charged with burglary, and during the burglary, he commits a murder. All right, so that is felony murder. So you've got a death occurs during, I'm sorry, let me get that a little clearer. A death occurs during a felony. So a lot of times people remember felony murder. So you're the driver in a getaway vehicle. Your buddy, you go and rob a gas station. The guy goes in to rob the gas station and he shoots the clerk, let's say the clerk shoots one of his buddies. Okay, so the clerk shoots the buddies, but during the commission of felony, somebody was killed. That's felony murder. Right? It's believe me, the hardest people to explain this to is defendants, because they say I didn't kill anybody.
My buddy died.
My buddy got killed, right? Yes, but you're guilty of felony murder because somebody died during the commission of a felony. Okay, so a violent felony. This is felony murder. So Kohberger, somebody dies during the commission of a burglary. He's now committing felony murder. So this is challenging the felony murder aggravator. Okay, so go ahead. Sorry.
Well, okay, no. That just blew my mind. Right. So that's what the burglary thing's all about.
Right.
Right, so that's because I'm being like, why have they kept this burglary charge there? It's so silly.
Okay.
Like, what's it got to do with anything? And
It's the
why do
felony.
they
It's
think?
the felony murder rule. Somebody
Yeah.
dies during the commission of a felony, and so therefore he's charged with murder, first degree murder, felony murder. It's called the felony murder rule. Okay, so that's why they're charged him with burglary.
Right. Okay. So and that's why that way they can have the felony murder aggravator.
Yes.
Right. Okay. Issues. There you go, Dali.
Whether felony murder can be predicated on a burglary itself, predicated on murder.
Okay, here, can I interrupt? I don't even know
Yes.
what's this, but I'll tell you what it's going to say.
Okay.
I love this stuff.
Let's
because
play
is-
this.
the stuff. What it's going to say is, it's turning the least culpable form of murder into the most culpable eligible for the death penalty. Okay, that's my prediction.
Oh.
The least culpable form of murder into the
Oh, an
most.
accidental one during a burglary.
Yeah, it's a felony murder aggravator. Because remember, this you have to say aggravator. So this is an unconstitutional aggravator because what it's doing is it's turning the least culpable form of murder into the most culpable form
just
of
wanna-
penalty.
You just want to rob a gas station.
I'm driving the
But-
car, I'm the getaway vehicle, and my buddy got shot, and now I'm charged with felony murder. Okay, that's probably the least culpable form of murder.
Sure. You're just
But
in
the
car.
felony, now you've got an aggravator that makes that eligible for the death penalty.
Gotcha. Ugh.
Right. Okay. So let's see.
Felony murder cannot be predicated on a burglary predicated on murder.
And this is called doubling. So this is what you're saying is you're doubling the aggravator. So you're saying you're aggravating something that is not, if you're aggravating something up from a simple burglary into a felony murder rule, and then you're aggravating it again to get the death penalty. So that's a
You're
double
really kinda
aggravation.
doubling down on that.
Right.
It is impossible to charge felony murder on the basis of a burglary with the intent to commit the murder in question. The state has given notice that it intends to show the murders in this case are aggravated because the murder was committed in the perpetration or attempted perpetration of a ... burglary ... and the defendant killed, intended a killing, or acted with reckless indifference to human life. In count one, the state charges that Mr. Kohberger committed burglary by entering a residence located at 1122 Keene Road, Moscow. Gotta work on the kerning there. With the intent to commit a felony crime of murder.
Yeah, I agree. Need some Z's. He didn't steal anything though. Like, where's this? They're completely making this shit up. Sorry.
Well, yeah, it's tricky because the facts of this case are not amenable to this aggravator. All right, so the problem is he entered the house in order to commit murder.
Yeah.
So that the felony burglary is trespassing with intent to commit a felony therein. So or a crime therein. So you would want to go in and commit a theft. You enter a house to commit theft. That's burglary. In here, he's entering the house trespassing to want to commit a murder. That's burglary. All right, but it's odd. It's odd because the problem is the aggravated. If you're going into a burglarizing house to commit a theft and somebody dies, now you're eligible felony murder rule. Here, it's not as good of a fact pattern for the defense because he's committing murder. That's the underlying felony. So it's a better aggravator than it is in other circumstances. So this is what I call bad facts. So from a defense standpoint, you've got to argue it because it exists.
Yeah.
All right, but you have to put this. They have to put this motion. But it's not the best fact pattern to take to the U.S. Supreme Court in this case.
So basically, the prosecution has manipulated it so that they can have that aggravator.
It exists, and they're going to. But which aggravators should they list? You see, this is why I'm saying here's a problem in the Florida statute, and it may exist in Idaho. I don't know. It's called aggravator creep. Like I said, they keep adding to the list, and the list becomes so extensive that it applies to every case.
Well, I read in your book about aggravator creep, and as far as I'm concerned, why do you need extra aggravators in a case where the crime is quadruple homicide? Like, that
Well,
should be enough, shouldn't it?
That's right. But like I said, the reason is because let's construct a non-arbitrary death penalty aggravator system. It would be one aggravator, multiple homicides.
Yep.
But the problem, the legislature can't resist, because once you've bought into the whole idea of death penalty, you have some heinous crime and you got a victim group, and you got the legislature of a bunch of politicians who want to say that we support the death penalty, we want justice for Michelle, and you add an aggravator and you add an aggravator, and all of a sudden you've got a Frankenstein statute of aggravators that applies to everything and becomes arbitrary.
Hey, Sol, how's it going? What's the difference between burglary and breaking and entering if burglary does not require theft?
The breaking and entering is an old statutory into common law definition of burglary. The modern penal code version of burglary is entering a structure, a trespass with a intent to commit a crime therein. So the modern version does not require a breaking and entering. There's a lot of old common law stuff about whether there was a breaking and whether it was an entering and what is a breaking. But all that's old school stuff. Now it is simply entering into a structure, trespassing with intent to commit a crime therein. So trespass plus theft equals burglary, for example.
But they didn't go with trespass. They went
No,
with
trespass plus murder is burglary.
Right.
That's a crime. Murder is a crime. So you're trespassing with the intent to commit a murder. So that's burglary.
All right. Do we want to look at the next one?
Yeah, let's look at the next one. You got some more time?
Yeah, a little bit.
Yeah.
Okay. You got enough for another one?
Sure.
Oh, yeah.
One more. For me.
So hang on a minute. I just accidentally took away the screen, and then
shut
I needed to go to. Shut up. Now I need to go to the HAC one because you wanted to look at that.
Oh yeah, hack. Let's look at hack. I call it e-hack. I usually put, because it's especially heinous, atrocious, and cruel. Okay, which is what the word is. But now, what is especially heinous, atrocious, and cruel?
Streaming with Hella.
Hey.
what that word does is, that is pro-death penalty people are using that word to distinguish between regular heinous, atrocious, cruel and especially, right? So they're trying to say that word somehow makes it more narrow. But I would say that that is just a vague word that applies to everything, and it does not actually narrow at all.
All right, so off you go, Mr. Ilya.
Now. Oh, God, I hope I don't have to sneeze. Bryan C. Kohberger, by and through his attorneys of record, hereby moves this honorable court for an order striking from the state's notice pursuant to Idaho Code 18-4004A the allegation that the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. This motion is made on the grounds that this aggravator is unconstitutionally vague and fails to narrow the class of eligible candidates for death partly. Did you do this one earlier?
He did it again.
Or is this
the same one?
I don't know.
No,
They're
not.
copying and pasting.
Okay.
They're copying and pasting. This is quite common. Like, you see the same spelling mistake across a bunch of different motions.
So they
because
copied
copy
it
and paste.
from, okay.
Yep.
That's funny. The U.S. Supreme Court has stated that the Eighth Amendment prohibition against cruel and unusual punishment made applicable to the states through the 14th Amendment provides a state from imposing the death penalty in an arbitrary and capricious manner. Yes. Instead, the sentencing body must... Okay, Junior. Sorry.
Did you get that cat out of here?
Sorry, Junior. Instead, the sentencing body must be provided with standards which will genuinely narrow the class of crimes and the persons against whom the DP is imposed.
We got the
See, now look there. So you've got...
again.
Again, back to Greg and Furman. So you notice the leading cases here, because what it's saying is this statutory aggravator is arbitrary and therefore renders it unconstitutional under Greg and Furman. Now, Furman's the one that struck it. Greg is the re-implementation, saying if you're going to have a death penalty statute, it must not be arbitrary. And they're saying this aggravator is arbitrary. It's the same, echoing the same idea over and over again, because they're saying, look, the U.S. Supreme Court said if you want a statute that's a death penalty, you got to do it this way. It's got to be non-arbitrary. And this aggravator is arbitrary, and they are right. This is a terrible aggravator in every statute. This is echoed through a lot of. And remember, you only need one. So if this one is applied, and it's one, and it's eligible, and it applies to everything, it's arbitrary.
So explain why this one in particular is arbitrary again.
Well,
please.
Tell me like I said, I had a case, the Colley case in Florida, where a woman was shot in the back of the head. She didn't see it coming. She was shot one shot to the head and killed. The court said that was EHAC. That was especially heinous and atrocious cruel. Okay, so tell me a scenario that fits the definition of first degree murder that is not especially heinous and cruel. In what way can you murder somebody that's not especially heinous and cruel? What would be that way?
That's about the best way to go out. I mean,
if you're walking along the road and you don't see it coming, somebody comes and shoots you in the back of the head, that's not cruel at all. I mean, if that is especially heinous and cruel, then everything. See, the idea here is they're trying to eliminate torture killings. Yeah. They're trying to say somebody is torturing you, cutting you up, making it so there's suffering and pain. And so it's especially heinous, atrocious. That is really bad. That's the example that they're trying to get at. But it has been broadened. The way it's interpreted by the courts in the state courts is so broad that it applies to every case.
The person doesn't even know.
Yeah, you're right. Okay, so sorry, what'd you say?
The person doesn't even know it's going to happen.
Well, in that instance, no.
Explain. Here's what I'm trying to say is, tell me an example of first degree murder that is not especially heinous, atrocious, and cruel. What is the fact pattern that this doesn't apply to?
Absolutely. So, and it's almost insulting to the families of the people who have lost someone to an intentional homicide, that theirs was not exceptionally heinous and cruel, whereas somebody else's was exceptionally heinous and cruel.
Well, another problem is the English language is vague in its very nature. There's a vague. And so these words, it's like we're going to add a bunch of words here. And the words make it limiting somehow. And what happens, you see the court say, okay, well, we could imagine a version, but in this case, this one is especially heinous and cruel. So basically, everyone that comes before them on the specific, this applies to. But there's some imagined one out there that we wouldn't apply it to. But in fact, like in Florida, they have 21 cases in a row that have upheld hack. So basically, it applies to everything. And so therefore, it's arbitrary. The hack is a terrible aggravator. This one and CCP, which is cold, calculated, and premeditated, are both terrible aggravators.
Aren't they pretty much the same thing?
Well, one of them's going to apply. Those, like I said, we need to, if you want to have a constitutional death penalty, it has to be very narrowly drawn. But it becomes so broad that you can't distinguish, and it's arbitrary, and therefore in violation of Gregg. This is the argument you're seeing over again. Let's see the next one we got.
And real quick, the more broad you make it, the bigger the chance the Supreme Court could come in and shut it down and narrow it even further, right?
Well, if the idea, again, here's the concept. First degree murders. I've got two sets of first degree murders. Some apply, some death penalty, some are death penalty eligible, and some are not. Okay, you got to be able to distinguish between those two. I got 20 files in front of me, and they're all first degree murders. And I got to say, in some objective way, these are eligible for the death penalty and these are not. And so you do that by applying aggravators. These have these aggravators and these do not. The one aggravator of multiple homicides, I could easily distinguish those files. If the aggravators instead, heinous, atrocious, and cruel, all of them apply. Therefore, it's just complete arbitrariness. There's no distinction between first degree murders. No. That is arbitrary.
Okay.
That makes complete sense, and it just seems like something that's been added in so that you can include it.
It gives prosecutorial discretion. It's a universal aggravator that applies to all first degree murders, and you can't have that under Supreme Court law. So let's look at one that's a little weaker. The weaker one is contemporary standards of decency. Let's talk about that.
I love this. I'm learning stuff. This is great. Okay, so Steve. What do you think? Vagueness?
Well, we can skip vagueness. We kind of talk. I mean,
we kind of have.
Let's do contemporary standards of decency.
Standards of decency. Let's go with the decency, shall
I don't know
we?
about that one.
No, Ilya wouldn't know anything about decency.
This one's a little more polarizing, so it won't be. I feel very strongly that hack and CCP is going to be the undoing of death penalty statutes across the country someday.
Really?
I mean, because I think that it is arbitrary. As just a matter of logic and fact, it does apply to everything. There is no distinguishing, and that is a problematic. Those both are very problematic aggravators. But let's see.
Okay, so
Yeah, and Solomon, real quick. I think that was Tennessee, but
I'll throw one more little wrinkle into this: the hack thing. And remember, Greg, we said there were 3 reasons that Greg upheld that statute. Right? The first was there was a statutory list of aggravators. The second was that the jury was bifurcated, and the jury made the decision on finding those aggravators. But the third one was mandatory Supreme Court review by the state Supreme Court. Okay. Now the idea, and this is a little esoteric too, but the idea behind that was that they could distinguish, as a matter of legal jurisprudence, they could distinguish between the hack, the especially atrocious and cruel, and because they would look at the full panoply of death penalty cases before them, and they would make a distinguishing argument. They would be a check on the jury, because the jury sees one case. The Supreme Court of Florida, for example, sees all of the death penalty cases as a matter of mandatory review. So they will be able to distinguish between some that are especially heinous and cruel and that are not, right? So there's a check on that aggravator through mandatory Florida Supreme Court or state Supreme Court review. Got it?
Yeah.
That makes it more constitutional. Now, the problem is in Florida is they are basically rubber stamping every death penalty. They are no longer doing what they call proportionality review.
Yeah.
Florida has announced that they are not going to do proportionality review as a matter of they just said they're not going to do it because it's a pain in the ass is what it is. And it's a lot of work. So they're just not going to do it. And they're pro death penalty anyway, and they haven't distinguished anything. So it's basically a meaningless check. So by action, they are depriving this aggravator of meaning and depriving they are doing away with proportionality review in Florida. And that to me renders Florida's statute unconstitutional, which is laid out in the book also.
Yeah. Florida is a whole different kettle of fish when it comes to the death penalty. And maybe that's a topic for a different stream, but really, I would not like to be on the wrong side of the law in Florida, I tell you what. Then
Can't even figure out hanging chads.
you can't even, what? Can't even figure out
Never
what?
mind.
Okay. All right. So, did you want to read this?
Comes now Bryan C. Kohberger, by and through his attorneys of record, hereby submits the following motion to strike the notice of intent to seek the DP on the grounds of contemporary standards of decency. More Americans believe the DP.
Oh dear. Oh, stray apostrophe. That really drives me nuts. Believe
Is
DP.
applied unfairly, then fairly. I'm sure they'll be swayed by a Gallup
now
poll
before-
from 2023.
Well, so here's the argument here. Now, this one is a polarizing one. This one polarizes between the left and the right. Okay, the progressives believe in a living, breathing constitution. They believe in evolving standards of decency. All right, conservatives are generally originalists. And they believe in it's kind of a certainty in the way it's the founding. And the death penalty was explicitly recognized by the United States Constitution and by the early founding fathers. It was part of the society, for better or worse. So was slavery. So you can't just say that settles the question. But so the thing is that this idea of evolving standards of decency and contemporary standards reject the death penalty, and the popular will is such that people are generally against the death penalty. That is this argument. Now, that appeals to certain progressive members of the U.S. Supreme Court, but a minority of them. I'd say this is a loser before a conservative U.S. Supreme Court. But it does appeal to the certain liberal caste, and of course, the Supreme Court might change over time. In 30 years, you might have a different makeup, and they might overturn the death penalty generally based on cruel and unusual punishment. All right. So is the death penalty by its nature cruel and unusual based on contemporary standards of decency? This is a left-right divide issue. So, and this is one that I would say I had a little philosophical because I'm generally pretty conservative, right? And I think that it's not an effective argument for your client to make this argument because you're arguing to the U.S. Supreme Court, which is a conservative court, and they're going to reject this. Yeah. I think you're better off, but see, people want to win on their ideological grounds. You know, we're both okay. Me, I'm the conservative, and the liberal here are both against the death penalty. I want to make the most effective arguments for my client. To me, the most effective arguments are Hack, CCP, and these other ones. This one is a loser. I don't need to win on my philosophical idea in order to defeat the death penalty. To me, the objective is to defeat the death penalty. And this is a loser because the court is conservative and they're not going. This isn't going to appeal to them. Okay.
But it could.
To a
liberal.
Could.
Look, I get what you're saying. This is about a moral point of view. Like it's about your feelings as to whether or not it's right or wrong. And different people are going to have different feelings as to whether the death penalty is right or wrong. And you can't sort of push your view onto others and expect them to be happy with that.
I wouldn't agree to that. I think this is instead a difference in judicial philosophy, jurisprudence. All right.
Jurisprudence.
So if you're going to say what the and I'm a conservative guy, so and I don't agree with this philosophical take judicially. All right. So what they're saying is that somehow if we all had a group vote around the world, and this goes with the international law thing, most people are against the death penalty. Therefore, the evolving standards of decency, we should reject it because most states are against it. All right. Well, that it doesn't, to me, that is not relevant to whether it's rational and constitutional. Like another argument, that's sort of how we got into the gay marriage, the case, because all these jurisdictions were for gay marriage and there's just a few outliers. So let's just go ahead and make it universal, right? Because everybody kind of agrees now, and that's evolving standards of decency. That's the same idea here. It's like, well, we've all kind of agreed that it's bad and let's just move on and let's just do away with it. Now that there is a progressive view, you know, though it's it's a living document, and what people think, it's supposed to be flexible. But the problem is there's no boundaries for that. There's no standards by which you can judge. And then it just becomes a popular will contest. The court should be instead an objective legal scholar. It should be applying rational rules and rational standards to these statutes, not just putting their finger to the wind and finding what's popular today.
What the popular view, and how do you work out what is actually the people's will? So if you're going to apply something like this, what are you going to go with, a Gallup poll? Like that's not.
But see, that's what you're getting. See, like look here, it says summary of argument, talks about national consensus and stuff.
Yeah, exactly.
And look, that's the thing I said, about 2% of the jurisdictions are applying all the death penalties. So that would say, well, 98% of the counties in the country are against the death penalties. Let's just make it 100%, right?
Yeah.
But it's not a popular poll. That's not the way the courts should apply things. That to me is not a rational, objective factor that could be in a conservative view.
Yeah. Okay, so do we want to continue with this one or not?
Well, you can read a little bit further. See, it says in recent years, a national
a national consensus in opposition to the death penalty has begun to emerge. The lack of an active DP in the majority of states. Funny. I think I just read something about that. Within the U.S. indicates that there has been an ideological shift and that the punishment now violates our contemporary standards of decency.
Yeah, see, and I agree with this politically. Okay, I agree with the sentiment. I agree with the thrust of what they're saying here. Is that a good legal argument?
Yes.
Yeah.
All right.
Yeah, that makes sense. The vast majority of modern civilized society has already abolished capital punishment because the execution of human beings by governments is recognized to be a violation of dignity and spirit of human beings. Look, I agree.
Yeah, I agree
But-
with all this, but it's not, that's, to me, that is improper. They're asking for the judges to do something they shouldn't be doing from a judicial standpoint.
And it's certainly not something I
If this is true, this is a legislative question.
It's certainly
Yeah.
not something the trial court judge is going to rule on.
No, but
should
this
be
is
for
but appellate courts.
Yeah.
Yeah,
Yeah.
No,
exactly.
You're right. It's a
But-
legislative.
Like going right back to the beginning of the stream when I was talking about like how people are reacting to what's just happened in court, Idaho versus Kohberger, people are saying, "Oh well, he lost. Like the judge overruled all these motions."
It means
Well,
nothing.
was he really going to sustain this? Like
Yeah.
no.
No, the judge
judge
was
judgment.
bound to follow the law. That's a trial judge is bound to follow the law, and the law is this is constitutional in Idaho at this point. He has to overrule this, but also the defense attorney has to make these motions because they have to do maximum due process, and this is what, and they're preserving issues for later appeal. And some of these are good, and some of these are bad. And I'm looking at them objectively. I'm no longer a public defender arguing these things, so I can give you my real opinion.
Yeah.
Because I've argued this motion in appeals before. I've argued
Right.
this very point, but I emphasize my other points, which I think are stronger and more amenable to the U.S. Supreme Court's conservatives.
Okay, so let's see what else we got.
What else we
I'm
got?
gonna head off.
Oh,
Sure.
Yeah.
Thank you.
Thanks. It was a lot of fun, guys. Nice.
thanks
seeing
for
you.
showing, man. Good to see you, man.
Nice seeing you, Steve. Bye.
All right. So, international law.
Say
Are we
that's going to
into-
be similar. That's except again, there's another conservative liberal divide. That one is talking about the international law community has ruled against this generally. There's ghosts in the machine.
Oh, hello, ghosts.
So the international and progressives think that we should take into account international law. A constitutional conservative would say, no, the Constitution is the law of the land. It's we, the people of the United States of America, not we, the people of the world. What the world thinks is irrelevant. And I agree with that sentiment. But however, what if you had a progressive Supreme Court? This is an appeal to that sentiment. And there is an argument that the death penalty is outlawed in many international bodies. And therefore, there you go.
Yeah, and when I saw that one come up, I thought, wow, U.S. judges really gonna like hearing about what the rest of the world thinks in regards
Some
to
will.
the death penalty. Really?
Oh, but see, back to the common evolving standards of decency. There was one Supreme Court justice that was really into that one, and that was Justice Breyer. So, and he would always write about that. And so there's certain arguments that appeal to certain judges. I mean, they're very well written on this. You know what those judges think. That's why I'm saying it's not like they're hiding their philosophy. They're putting it right out there. And like Breyer's like, this is the problem with these things. Nobody joins him. It's his little majority, concurrence or dissent. But the one, that's why I'm saying that we all agree the death penalty can't be arbitrary. As a matter of the constitutionalists, the conservatives, the liberals, all of them agree that it should be arbitrary. That's why the hack argument, the CCP argument are very good.
Okay, so we went past that one. So motion to strike states notice pursuant to IC 18404 on grounds of arbitrariness.
We've talked about that enough, and we've
I'd
striked it.
like to look at this one.
Okay,
So motion
let's
to strike the death penalty. I have questions about this one. So this is, hang on, it's just taking its time to load up. Hello. Okay. Alrighty. So this one is about a tension between two constitutional rights, and let's read it out. So comes now Bryan C. Kohberger by and through his attorneys of record, and hereby moves this honourable court for an order striking the state's notice pursuant to Idaho Code 19-4004A on the grounds that Idaho's statutory and constitutional guarantee to a speedy trial prevents the effective assistance of counsel in death penalty cases.
It's
issues.
interesting.
Yeah. Idaho requires all criminal defendants to be brought to trial in 6 months from the arraignment on an indictment pursuant to statute and its constitution. In Idaho, the right to a speedy trial is defined by IC 1930-501 as it was at the adoption of the Constitution. The Idaho Constitution guarantees a speedy trial, except where there is good cause for delay or the request for postponement came from the defendant. 2. The Idaho Constitution requires a fixed amount of time constitute undue delay. This court should adopt the 6-month line adopted by our legislature. B. A defendant in Idaho can never request additional time without losing his right to a speedy trial. A capital case cannot be prepared in 10 months. 3. Idaho cannot force a defendant to choose between his rights.
Okay, so this is an excellent motion. This is a good one. I'll say this is very good. So here, the first concept, this lays it out. I mean, this is a good lawyer who wrote this, because to me that summarizes it in a very easy to understand logical syllogism, right?
Well, I even get it. I even get it. I've liked this one since it came out, and I've been wanting to ask you about it. So,
well, but there's a lot of complication here. I'll try, but and I can expand into the complication quite a bit, but let's just stick with that syllogism, because that's the framework for the argument. So the thing is that you shouldn't be forced to choose between rights. Okay, I have the right to a speedy trial.
Yeah.
And I also have the right to say the right to remain silent, for example, or I have the right to be presented with the evidence against me. I have a right to a full and prepared and adequate defense. Okay, so let's take the first one and the last one: the right to speedy trial and the right to a full and adequate defense. Right? I have a right to it. Well, what they're saying here is that there is based on what the death penalty requires of the defense attorney, there is no human way a human being defense attorney can adequately prepare for trial given the statutory speedy trial time of 6 months.
Yep.
All right. And when I ask for more time as a defense attorney, that is deemed a waiver of your speedy trial right. So just the mere asking for more time waives speedy trial.
Yep.
Therefore, I'm being forced to choose between a fair trial, a right to have a prepared defense attorney, and the right. I have to give up my speedy trial rights in order to get the other right. Or I have to go to trial unprepared. So either way, I'm giving up my rights. So the death penalty is unconstitutional because it's forcing me to choose between those two rights. That's a pretty good concept. I like this concept.
And that's exactly what happened. I remember, because he was forced, his hand was forced. He had to waive his right to a speedy trial because there was so much left to do at that point in time. And people weren't even talking about the fact that in the background, they had to do the mitigation work, right? So
that's a good point, because if you read death penalty designs, mitigation is required. So you must prepare mitigation. To not prepare mitigation is ineffective assistance of counsel. And mitigation is that's one of the major costs involved in a death penalty system, is that every time the state requests death, even if they eventually plea or get life, there must be a mitigator hired. And that's a minimum $25,000 to $50,000 right up front. Yep. And it takes a lot of time and a lot of effort. The thing is that the system, as it's designed, requires inhuman levels of competence and preparedness. Louder for
those in the back, Gosney. Now, this is really important stuff, because I don't know how much you've seen of what's been happening with the Kohberger case over the last few years.
I haven't really been following it.
So many people are so angry about how long this has taken, right?
Well, but my friend,
it's 2 years.
2 years. My friend Rosemarie, who is our lead capital trial attorney in Felucia. Now she's with the Jose Baez firm, and she's handling a couple death penalties for Jose Baez. She's great. She's the best trial attorney I've ever been around, bar none. And she says that when she got a death case, she would say to her client, we're 2 years away from a trial, at least. And some jurisdictions, it's much more. That was in Northern Florida. It depends on jurisdiction, but minimum 2 years. So this is at odds. There's no way to prepare adequately for a death case. There's so much complication because remember, we're talking about maximum due process. Look at the motions that are filed here. Every one of these motions, if there is a possibility of a motion, you must argue it.
Yeah, absolutely. So this whole idea of mitigation and the work that has to be done is it's very misunderstood, and it's something that is not spoken about or considered by lay people. And the mainstream media is, in terms of when I speak about mainstream media, I speak about like court TV and things like that. They don't talk about it either, even though they know it exists. They don't talk about it either because they like to play up this whole idea of, oh, it's taking so long, just take it to trial. They know that in death penalty cases, there is this mitigation work that needs to be done. But they don't talk about the fact that that takes a lot of time. They just play up this whole, the defense is dragging their feet. No.
Well, and if you read Death Penalty Desired, which is my novel, my fictional crime novel, not a misogynistic smut novel, a crime novel, fictional crime novel with fictional people in it, but it's a death penalty case in the middle of it. And you will see the bifurcated trial in the middle of that book. There's a trial and there's a mitigation, or there's a penalty phase. So what happens is in a death penalty case, and remember under Gregg, there's three things that made it constitutional. One was statutory aggravators, mandatory Supreme Court review, and then the third one was bifurcated trial. So we have a guilt phase and we have a penalty phase. Don't have that in other cases, but the jury must decide the death penalty. Okay, you can't, and there's a lot of case law in this. So you have a guilt. So the guy's guilty. Now the question goes to a penalty phase, and is it life or is it death? Life in prison without the possibility of parole, or the death penalty? That's the only question before the jury, and the jury must find unanimously, except in Florida, which will get struck down. See, this is the thing. If you're pro-death penalty, why the hell are you putting together a Florida death penalty statute that is automatically unconstitutional? It's already been decided by U.S. Supreme Court. You must have unanimity. But we've got to go. And in fact, this is interesting. And I'm randomly firing off thoughts. I talked to one of the Parkland shooters jurors. I don't know if you know about the Parkland shooting.
Oh, yeah.
And one of the life-giving jurors I've spoken to at length, and about this very issue of mitigation, because everybody is all wrapped up in aggravation. They understand these aggravators. They understand statutory aggravators. They understand this is cruel, this is unusual, this is bad, this is multiple homicides, this is that, right? But on the other side of the equation, a fair jury also has to consider statutory and non-statutory mitigation. They have to look at the facts. They have to look at the person who's committing the crime, right? So, and weigh that against the crime. So and this is the problem. People that are pro-death penalty are generally looking at the crime. People that are against the death penalty generally look at the circumstances of the perpetrator. Okay, and that's a good distinguishing factor. So say, well, he did this, therefore he must die. Well, what if the person was a mass murderer and they were 3 years old or 10 years old? Well, the fact that they're 10 years old is mitigating. So we don't put 10-year-olds to death for mass murder, even if they did it, right? Well, what if somebody is low IQ? What if somebody is like basically mentally disabled to the point that they're 50 IQ or something, so, and they kill 5 people? That's mitigation. You have to consider that when putting it. They are less culpable than somebody who's higher IQ, like Kohberger, right? Or here's another mitigate. What if somebody, and people don't like to look at these things, right? So in the example of the Parkland shooter, the mitigators were strong. He was 18. He was suffering from an fetal alcohol syndrome for many years. There's a lot of surrounding circumstances that had to be looked at to weigh against life or death question. And those are difficult questions. They're not easy questions for anybody, especially for a jury who actually has to make the decision. From side snipers on the internet who want to just say, well, he should just be put to death or he should be given life or whatever. These are not easy. These are not easy questions. They're very difficult questions. And a jury has to weigh the aggravators against the mitigators in an individualized way at a penalty phase of a jury trial. After the jury goes guilty, they have to weigh them and then decide life or death. And in order to prepare for that penalty phase, it's very difficult. It takes a lot of preparation, experts, trial prep. In fact, we have mitigation teams. We have mitigation attorneys. So you have a trial attorney and you have a mitigation attorney.
Can you explain mitigating factors? Please,
it's anything. There is no limitation on mitigating factors. Okay. It can be anything. And this is one people you don't understand. There's statutory mitigators and there's non-statutory mitigators.
Yeah, that's what I wanted you to talk about, because we've talked about aggravators. We haven't talked about mitigators. So
well, and there's, like, for example, victim impact statements. Victim impact statements should not be presented to a jury because those are non-statutory aggravators. If it's a non-statutory aggravator, it's not an aggravator and it's improper to be placed before the jury. If it has to be statutory, it has to be specifically listed by the state, and they are limited to those aggravators. The defense, on the other hand, has unlimited. They can argue anything as a mitigator. Anything. I got a B on my report card in 8th grade. That could be a mitigator. Whatever you feel, you are not constrained in any way as a defense attorney for providing anything to the defense, to the jury that you think is mitigating, including and especially an appeal to simple human mercy.
Yes.
Mercy can be that mercy must be considered by the jury. And you can't define that. How do you define that? It's an individualized choice of every individual juror in that penalty phase. And how do I prove mercy? There's a burden of proof question. There's a lot of complicated questions here. But the penalty phase is a whole different beast that only exists in death penalty cases.
Yes, and it takes time to prepare for the penalty phase, and it starts from the very beginning of the person being indicted and having the death penalty on the table, correct?
Repeat that question.
So the death penalty phase, the sentencing phase in a death penalty case starts from the very beginning. So when the defense attorneys are given the case and they know that there's a death penalty on the table, they start the mitigation process right off the bat. Like they're already working on it, even though you would think they'd be working on mainly the guilt phase. They have this whole other workload.
Well, you have teams, and like I said, you get a team of lawyers. You'll see that a lot in defense attorneys. You'll have a defense team, and you'll divide that up in from guilt phase and penalty phase. And I think that's a very smart idea from a defense standpoint. You should always do that, because usually in a guilt phase, if you're actually contesting guilt, you'll have a defense attorney up there saying, he didn't do it. And then the jury comes back and says he did do it. To have the same attorney get up there and say, okay, we admit that he did it, but here's the mitigators. It makes
very weird.
It's weak. So what you need to do is switch up defense attorneys and have a separate mitigation defense attorney to present that evidence.
Yeah, I've watched trials where that's happened, and it's very strange when they just suddenly turn around and go, oh, okay, fine. If he did do it, then here's the reasons why you shouldn't put him to death. It's very strange. Okay, I have a couple of questions before we move on, because what I have here to look at is the judge's ruling against that motion that we were just looking at, because, as you said, it was a good argument. So I wanted to just look at what he had to say about that. Now, Mickey's headphone says, Gosney, do you agree that the concept of having a DP qualified jury is inherently biased and prejudicial because the defense isn't allowed people against DP to qualify? Ooh.
Well, that's a good question. And there's some academic, there's a really good professor at University of Miami named Scott Sunby, who is kind of the expert on this issue. And I haven't looked into this as precisely as he has. I'd refer to Scott Sunby on this. But generally, the issue here is that one of the things the state gets by asking for the death penalty is a more favorable jury. So the concept here is that the state will ask for a death penalty to get the good jury, get the guilty phase, and then just say, okay, we'll allow them to go life, because they got a more pro-state, pro-guilt phase, because they have to agree that they'll put in the death penalty. So I would not be eligible for a death penalty jury because I'm religiously opposed to the death penalty. So you can strike everybody who has religious objections like me. Right. I would never vote for a death penalty. I took the job in Miami. I explicitly stated I will not assist in any way with death penalty cases. And they hired me with that basis. But the thing is that I would be not eligible to sit on a death penalty jury. Now, whether or not, because the opposite is also true, because there's some people that say, I am always for the death penalty in first degree murder. All right. And those people are also explicitly excluded. You have to have jurors that can listen to mitigation as well as make factual. They have to be fair and down the middle. And it's very complex jury selection. It also has to be individualized. There's also a big debate about maximum due process. And maximum due process, to me, requires individual voir dire of jurors. That means you can't have a group and ask group questions. You sit them down one by one and ask them individually alone what their views are and get it out there so that you can then explicate which is the fair juror or not. This is a complicated issue, but it's a very good question.
It's a great question. Mavka asks, what about trifurcated trials? And this has come up in this case.
I saw that. I don't know what I know. Bifurcated. What is trifurcated here? What's three?
I'll go ask you.
Well, there's a motion. We can look at the motion because there's a motion.
Yeah, we can look at the motion. All right, so we'll go back here. Hang on, where are we? I'll just search for it. So Okay, motion and memorandum in support of motion to trifurcate the proceedings and apply rules of evidence.
Okay, let me talk a little bit, while you find that, let me talk a little bit more about the problems with death penalty qualified jurors that I think juries that is problematic, because I have a right as a citizen to serve on a jury. So part of the problem in this, part of the concept, and if you look at jury appeals, having a fair jury is not just the right of the defendant. It is more so the right of the citizen himself to serve on a jury. So if somebody gets excluded based on race, for example, in Florida, the way the law comes is that is not an offense against the defendant. That's a defense against the individual juror. Okay, so the state is violating the rights of the juror by excluding them on improper grounds. Well, I, as a religious Catholic person who's against the death penalty, have a right to serve on a jury and have my voice heard. To strike me based on my religious beliefs violates my rights as a citizen of the United States and my religious beliefs. So there is a problem inherent in qualifying a death penalty jury because you are striking people for their religious beliefs, putting your First Amendment rights at issue, and just, again, choosing between rights. I can't serve on a death penalty jury because I'm Catholic. You see, there's a problem there. It's a big problem. Yeah.
And thank you to Dali for the One Excited Utterance membership. I suppose you're okay. I take back what I said about you.
There's another Catholic. Dolly was Catholic.
Okay, so comes now Bryan C. Kohberger through his attorneys of record and hereby submits the following motion and memorandum in support of motion to trifurcate the proceedings and to apply the rules of evidence during eligibility phase. So proceeding with a bifurcated trial in which non-statutory aggravation is presented without the rules of evidence being applied will result in a violation of Mr. Kohberger's state and federal constitutional rights, including the 5th, 6th, 8th, and 14th Amendments to the United States Constitution.
Yeah, I don't understand this, sorry, but go down to argument. Let's see what this is.
Yes, go. Idaho's death penalty scheme provides for two phases. One where the culpability of accused is determined, yes, and then if they're found guilty, a sentencing phase, commonly called penalty. Problematically, at the penalty phase, the jury must actually make two determinations. These two determinations are: one, whether the defendant is eligible for the death penalty, and two, what is the appropriate punishment. Under Idaho Code Section 1925-15-3B, a person is only eligible for the death penalty. The jury finds beyond a reasonable doubt at least one statutory aggravating circumstance. If the jury determines that the defendant is eligible for the death penalty, then it must decide if it is the appropriate sentence. Where a statutory aggravator is found, the defendant shall be sentenced to death unless mitigating circumstances which may be present are found to be sufficiently compelling that the death penalty would be unjust. Okay, we've got that. In order to sentence the defendant to death, both findings, eligibility and appropriateness, are required. The jury shall not direct imposition of a sentence of death unless it is unanimously finds at least one statutory aggravating circumstance and unanimously determines that the penalty of death should be imposed. Combining these two distinct determinations into one sentencing proceeding violates a defendant's state and federal constitutional rights.
Okay, so this is interesting, and they're citing Apprendi. I love Apprendi. Apprendi is one of the best Supreme Court decisions, I think, ever in the criminal context. It's a great. I love Apprendi. Okay, and this is fascinating. I've never seen this argument, and this is a good one. There's lots of clever lawyers out here. Like they say, I'm the expert. I just know something about it. All right, I've done it. I know this stuff. But there's a lot of great death penalty lawyers out there who are obviously working on this case and are behind a lot of these things. And this is a very clever argument based on Apprendi. Okay, so let's talk. What is Apprendi?
Yeah.
We in the common law, we have juries. Okay, so the question is, what is the function of a jury in the system? And because in the civil system, there's no jury, right? So you have judges that make the decisions on everything. But in the common law, the English common law, basically you're in an EU country, we have juries. Well, what does a jury do? Well, a jury, the Apprendi says the jury is the fact finder. The judges are the lawgivers. Okay? So you have a lawgiver and a fact finder. So in this case, what is a fact and what is a law? And there's a lot of great case law on this. And actually, Apprendi is great because it allows you, let's talk about, and this is a long subject, but it's interesting. Enhancement of a crime, for example, burglary. And then you have burglary with the commission of, with the possession and discharge of a firearm. Enhances the penalties under 1020 life. There's a firearm enhancement. So you have burglary, but then you got burglary with a firearm with discharge. So there, the jury must find the facts of burglary, but then also the jury must find the facts. In order to find the enhancement, they have to find that the person possessed a firearm and discharged a firearm. So you have a jury interrogatory asking burglary, and then you have possess and fired. Okay, because the judge cannot make factual findings.
Yes. Now,
it may be obvious, there's a video, but if the jury isn't specifically asked whether the firearm was possessed and fired, the judge can't make that factual finding because the judge is the lawgiver, not the fact finder. Does that make sense?
Yes.
Okay, when you apply this, it makes a lot of sense. It's a great decision because it's really clear about what the function of the jury is and what the function of the judge is. All right, so now let's apply that into a death penalty statute.
Yep.
And what is a fact? Well, a fact that increases a sentence, an aggravator, is a fact that must be found by the jury unanimously. So, and this is there's a lot of weed stuff here. This is so complex, but it's fascinating. So for example, for them to find at least one statutory aggravator, the jury must find each aggravator unanimously in order to find death. You can't just say some of these apply. They have to find each individual. There has to be an interrogatory. Do you find EHAC? Do you find multiple victims? Do you find CCP? Yes, unanimously. Yes, unanimously. Yes, they have to be individualized and factually find. Now, this has gotten muddied by prosecutors, but this is the way it should be done under Apprendi because the jury is the fact finder and they must find aggravating circumstances beyond a reasonable doubt unanimously.
Yes.
All right. So you get it? So in this case, what they're saying is they're combining a penalty phase, which is a fact-finding function, as well as a judicial determination into one proceeding. Because usually the judge is the sentencer.
Yes.
The judge is the one but in a death penalty case, the judge is not the sentencer. The judge cannot sentence the death. If the jury comes back life, the judge cannot override that. It must be life. If the jury comes back death, the jury can override and go down to life. But in order for the judge to impose a death penalty, they must find eligibility for the death penalty, and the way to find eligibility is through this factual finding. So what you have is a factual determination by the jury. Bifurcation is guilt phase, penalty phase 1, which is statutory aggravation. We find this aggravator beyond a reasonable doubt, but then the jury becomes the sentencer also, which is a whole different concept. They are acting as the sentencer. They are acting as the judge, which is not a fact-finding function. That is a judicial function that is unique to the death penalty. And they're saying they need to have 3 phases. That's fascinating. I like the argument.
So the jury would then, so they deliver their verdict as to the aggravators, and then they go away again and deliberate on the penalty. Is that what they're asking?
That's for? That's what they're saying. But see, and remember I told you about, think about this. One of the reasons that Gregg, the 3 functions in Gregg, and one of them was mandatory Supreme Court review, and that was because they had to do a proportionality analysis. That is because the judges on the Supreme Court can supposedly look at all the death penalty cases and say these are the worst of the worst, and these are not as bad. When the judge only gets one. Well, when the jury is acting as a sentencer, whether they should be able to determine, they should be able to present evidence that this is not the worst of the worst. They should be able to present different fact patterns to say, look, here's people that got life whose fact patterns are much worse than the ones that we're looking at here. We should be able to present that to the jury as far as a proportionality argument, because they're not making a factual finding, they're making a judicial finding, and the jury should be able to hear the proportionality stuff.
Yeah.
Okay, so this is a very good argument.
Well, it didn't work, but
sorry, this is complex stuff. This is not easy.
No, thank you. I got it though. It took a bit, but I got it. So, because when they went for the whole trifurcated thing, I was like, what do they want the jury to leave and then come back, or?
Well, but they do that. They do that already, because you have a guilt phase and then a sentencing phase.
Yes, but I didn't know what they meant by the third one. So
well, that's what it is. They're distinguishing between.
Now I get it.
They've got to find which aggravators apply beyond a reasonable doubt. And then they've got to say, after they do that, if they say, okay, he is eligible, we do find these aggravators, then we want a phase on, is it life in prison without parole or is it death penalty? That's good.
Also, they only need to find one aggravator,
right,
to be on a reasonable doubt, right?
Yep.
So even they can go and put forth 4 aggravators, the state, but they only need to find one,
right,
for the death penalty.
Yes,
right?
In order to be eligible. If they find no aggravators, they're not eligible for the death penalty.
Yes, right. So say they find 1 and 3 others, they go, nah.
Well, they could find all 4. They could say all 4 of these apply. So we've got 4 aggravators.
But let's assume they only find 1, right?
Okay.
So, but then they have to then go and reflect and come back and do the sentencing phase.
And the sentencing phase, remember, is, okay, we found these aggravators. Now we're listening to the mitigation. And do the aggravators or the mitigators outweigh the aggravators? They have to weigh these things and say, okay, the guy is 18 years old. He's suffered his whole life. He's been on drugs. There's a lot of, he was abused, and maybe he was abused by the person he killed. And there's a lot of mitigation. And so you've got to weigh those against the aggravators. And that's a difficult question. And that's why you want a fair jury that listens to mitigators and can sentence to present that. That's why you have a mitigation expert. And that's why you have a whole bunch. That's a very complex and difficult thing to present mitigation in a death penalty case.
But the mitigation would also be presented at the second phase, though, wouldn't it? So it'd still be a
Yeah, well, that's what they're
a-
doing. Generally, it's combined. So generally, you have they find the aggravators and the mitigators are presented, and then the jury's given questionnaire as to which aggravators they find, and then they're asked to say, do the aggravators outweigh the mitigators, and it's all done in one penalty phase proceeding. And they're saying they need to bifurcate that penalty phase into two, which is good. I think I agree with that. I like that.
Actually, wouldn't it be interesting if it actually went ahead? I mean, I don't think it's going to, but wouldn't it be interesting if it did? Because I've never, you've never even heard of such a thing. And
well, it's a clever. I know Apprendi, and I love Apprendi. I think Apprendi is a great decision. But see, people are being very thoughtful. These are very smart lawyers who are looking at it. And remember, maximum due process. Or is this unreasonable? This is very rational and logical to me. And objectively, and it makes sense to me. And I think that this is to squish it all together and let's just decide death.
Yeah.
I don't know. I mean, there's an argument here, and it's a very thoughtful and well thought out legal argument. And this is not just one person. This is a team of defense attorneys that have put a lot of thought into these things. So
yes, absolutely. Let me see if I can get back to where I was a moment ago. I've got so many tabs open. Hang on. I know that was a Apprendi. All right, so we were talking a moment ago about the motion to strike death penalty. It was only called motion to strike death penalty, and that was just a minute. Yeah, that was the one about the speedy trial, and then him having to choose between two constitutional rights. And I wanted to show then the response from the court. There it is. There we go. I found it. Right. The response from the court on that one. So the court's given a 55-page order shooting down every one of these motions. But this one in particular, I was wanting to see what Judge Hippler's response was. So, motion to strike death penalty on grounds of state speedy trial preventing effective assistance of counsel. In seeking to strike the death penalty, defendant's multifaceted argument begins with the premise that the court should overrule decades of Idaho appellate precedent and conclude that the right to a speedy trial guaranteed by Article 1, Section 13 of the Idaho Constitution should no longer be governed by the Barker factors, but should be subject to a 6-month speedy trial clock. He then asserts that, as a capital defendant, he cannot obtain effective assistance of counsel within a 6-month period. Thus, at the time he waived his statutory and constitutional speedy trial rights, he was presented with an unconstitutional Hobson's choice between his constitutional right to a speedy trial and his constitutional right to effective assistance of counsel. He argues this choice rendered his waiver involuntary and deprived him of his constitutional speedy trial rights. The only remedy, he contends, is striking the death penalty. The state points out that well-settled case law, which is binding in this court, provides otherwise. Further, the state notes that defendant waived his speedy trial rights, which is dispositive of any contention that such rights have been infringed. The state is correct.
Okay, so yeah, and this is what I'm saying. The state is going to. There's precedent out there. The judge is going to rule for the state on these things. The reason it's a 50-page order is to protect it from mandatory Supreme Court review. And I will say, speedy trial is a very complex subject. And there's statutory speedy trial and there's constitutional speedy trial. All right, those are two different things. They're trying to leverage the statutory speedy trial into a constitutional argument, which is, there's a lot of wrinkles here. I will say that very rarely does anybody ever get away with something because their speedy trial rights are violated. Generally, the speedy trial right, what it allows a defendant to do is force a trial, not get away with something. This is a very a lot of non-lawyers misconstrue it because they think, and I will say defendants love this because they're like, oh, my speedy trial rights are violated, right?
Yeah.
Almost never. Now, there are circumstances. I remember we had one case that we actually won on speedy trial grounds, which was unbelievable. But there are cases that happens on, but they're so infinitesimally rare that it's basically a non-thing. But nobody gets away with murder or it gets away with anything because they're speedy trial lawyers. What it does is it gives the tool to the defense to force a trial. Force the state to trial. And that's what it really does. It's real effect. I mean, I'm actually a little stronger. I think it should be a little more assertive. It shouldn't be so easy for the state to get around. But in fact, the case is people waive and it's over. So
yeah, I mean, he did waive his speedy trial right. It's unfortunate because he had to. And this happens so often. The defendant has no choice, really. I mean, when it comes down to it, his counsel would have said to him, you've got to, like, if you want to really fight this thing, you've got to give us time to prepare.
But see, there's a difference in the judge is saying, as a practical matter in this case, under current precedent, this is without merit. But I think that the larger argument, again, why it's part of the block of motions that are all going to get denied, is that the defense is saying, forget Kohberger in this specific case. As a matter of structure, the death penalty structure, because it's so complicated, the timing doesn't work, and structurally it's defective. All right, so yeah.
It's a great argument. It makes complete sense. And Mickey's headphone says, Gosney, hypothetically, if you're working on preliminary hearing for 6 months, then a week before that date, the state got a grand jury indictment without warning, isn't that forced? And he may have another comment coming through because also we're now at a point where it's 2 years down the track and we're still, well, I'm saying we, but the defense is still waiting on discovery from the state. It's been an absolute uphill battle to get discovery out of the state. We've had 6 motions to compel, I think 18 or 19 supplemental discovery requests. I haven't been following this at all, but I will say that one thing that impressed me by the Idaho prosecution team was that it seemed to me that they were very cagey about what they were saying to the media. It didn't seem to me at the early stages that they were playing a lot of media games with this case, that they were basically holding their fire, accumulating their evidence, taking it very seriously, and being very cautious on it. That was early on. I haven't followed it since it first went down, but that's smart. And this is the thing. And the defense attorneys seem to me that they're really ramping up. I got to say, the Idaho criminal bar here looks to me to be taking this very seriously and are doing good jobs on both sides. Now, I haven't followed it in a long time, and I know people are wanting to speculate on what the evidence is or is not. We won't know that until the trial. Okay, so people are speculating, well, this happened and this happened. You don't know because the state is not playing a public relations game from what I remember. Gag order, okay. Yeah, there is a gag order. Look, the thing about it is, Steve, and what we were discussing with Andrea the other day is they came out with this probable cause affidavit right at the start, and it was full of a lot of conjecture, a lot of sort of assertions based on they had experts in there, or experts who would say that, oh, this is what an offender would do is turn their phone off if they were going in to murder some people. So that therefore, based on that, we can assume that this is the case. There was a lot of things in there that have since been debunked or that the state has had to go back on. So there's
I'll say that I'm not commenting on that. I mean, I shouldn't even do that because I'm here to talk about the death penalty generally. I haven't been following. Andrea Burkhart is she is the person I would go to and listen to from a defense perspective about what's going on in the case. She's been following it. I know you have. I have not been following. I'm coming on because I want to talk about the death penalty generally. And see, that's like in this speedy trial case, what happens in this specific case isn't necessarily important relative to the constitutionality of the statute as a whole. Okay, so the specific case, maybe Kohberger isn't being harmed by the speedy trial violation specifically, but generally the statute is defective because generally it's structurally problematic from a speedy trial, like what they're bringing up here. Same thing with the hack aggravator, because it's like, okay, well, look, in this case, these murders were especially heinous and cruel. We can all agree on that, right?
Yeah.
Okay, so we all agree on that. So it's not a problem in this case. But the problem is that the aggravator applies to all cases. So structurally, the statute is unconstitutional. You see, so it's an argument that's made to attack the statute generally, not specifically. And this is that's what the appellate courts are supposed to do anyway, is look at the statutes and say, are they constitutional as applied to everybody? Not in this particular case necessarily. There's an as applies challenge and there's a breadth challenge. So there's difference analysis, but these are arguments that are made to attack the statute as being unconstitutional in nonconformity with Gregg, because the statute is arbitrary.
Okay, so I think that might be all I wanted to cover in regard to the actual documents, unless there's another one that. Hang on.
No, let's just. Maybe we can just deal with that. Those are some good. That's fun stuff, and I really thank you for the opportunity to come on and talk about it. Of course, a lot of these things are covered right here.
Oh, yes, your new book.
Did you read this by any chance?
I read it. Yes, I'm nearly up to the end of it. I was just like mind blown by the end. It is a law book. There is that you can read it as a layperson, and I did, and I found it extremely educational. I almost feel like I'm not quite as much of a fake lawyer as I was before. I can't opine quite like you can, but it is really eye-opening. There's a lot in there that it really opens your eyes to what?
Get rid of that. Let's get rid of the thing, docket. I want to see your face. I can't see your face.
Oh,
there you go.
There's a lot in there that opens your eyes to the amount of work that goes on behind the scenes that people just aren't aware of. Like, I would like you to just talk for a moment about the amount of time and resource that goes into a death penalty case, as opposed to a case that doesn't have the death penalty on the table. So you actually you wrote about this in the book, and I don't think that anyone who's not in the business would be aware of the litigation that goes into it, not even just pre-trial but post as well. And it's important because it's maximum due process.
Right, and that's the title of the book is Death Penalty Designs Maximum Due Process. And that this is an analysis of federal law as it applies to the death penalty generally. So it's federal, and I'm using Florida statute because that's the one I've dealt with, about all the constitutional infirmities in the Florida's death penalty statute. Now, there's a public policy debate that's separate from that, which is laid out in death penalty debates. And then there's death penalty desired, which is the fact pattern, which gives you a feel for how an innocent person can land on death row, as well as an experience of what death row actually is and what the process actually looks like. I mean, that book is a crime, an investigation, a trial in the middle part, and then a tour through death row at the back part to kind of give you an understanding of how a trial works and how an investigation works and what a death penalty case looks like with real law applied. because there's real law behind that. And most of that case is drawn from real experience. Most of that book is drawn from real experiences, including the sensational, the sensational parts about the prosecutor that got me fired and prosecuted by the prosecutor's office. That stuff is basically founded in stuff that I actually observed prosecutors doing. It's not like my imagination. I mean, these things happen. The death penalty is brutal. Murder is brutal. And these are difficult topics. And, people, they're squeamish. They don't want to see it. Well, don't read the book, because that's what we deal with. I mean, murder scenes are bloody. My wife was even talking the other day. We were watching this show, and she loves crime shows. And there was a scene where it was just blood all over the place. And she's like, that's ridiculous. That's not the way. And I'm like, you haven't seen a crime scene. I've seen a double homicide with knife. The blood is unbelievable. And but so the first book should be read in that order: Death Penalty Desired, Death Penalty Debates, and then Death Penalty Designs. And this Designs is a very complex law book that lays out what they're doing here in this motion practice. Now, you asked me about the costs involved. That's best addressed in Death Penalty Debates, which talks about the cost issue. But this also shows, this motion practice shows you how difficult the law is. And it's hard to find. I really think the level of competence that's required of the attorneys in a death penalty case is inhuman. One of the problems with the death penalty is there aren't enough competent people that you can buy to administer it in the way that it should be administered. Most people are incompetent.
And that makes it very difficult to justify continuing to have it. I feel like, apart from all the other arguments against its existence, having it there and it costing so much, it taking so much time up, and then even if you are for the death penalty, most people stay on death row for what? How long?
Well, the quickest it could be administered is 6 years that we can possibly. There's an example. We just had the last person that was executed in Florida
was like desperate to have.
Desperate. He wanted. He was cooperating.
Yeah.
The other side is the other end is 35 years. But the thing is the problem is if the death penalty went away tomorrow, we would be left with all the existing problems of the world. Doing away with the death penalty is not going to affect the real problems that confront the criminal justice system or humanity. Same thing with if you executed everybody on death row tomorrow, we would still be left with the same problems and the same criminal justice problems. It really is it's a distraction that politicians love because it does distract voters from real issues confronting them. But the problems confronting humanity are difficult and hard to solve. So it's easy for a politician to come up with an idea to say, oh, well, the death penalty will solve all your problems, and let's get everybody fighting over this issue, when it's really a side issue relative to the big issues confronting humanity.
Yeah. And so that brings me to Solomon. And hi, Solomon. How are you going, mate? It's so good to see you. Steve, why bother to maintain the death penalty? Is it more costly than a life sentence, and it has created situations where the state is committing human rights crimes with botched executions? Oh, the botched executions.
Right. Well, I think that was in the death penalty? Yeah, the list is actually the best method of execution is firing squad.
And that's actually what they're proposing for Kohberger.
Yeah, the best one, the worst one is lethal injection, which was death penalty desired, was based around the lethal injection, which does fail a lot more than people realize. Now, the cost issue in death penalty debates, I've looked at the cost issue. My best guess and my best research that I can come up with, because it's a very polarizing issue and people create studies and they're flawed, and I'm not qualified enough to really dig through them. But the ones that I'm most confident in, it's about 4 times the cost of a life sentence. So to impose a death sentence is about 4 times the cost. Now, I've seen studies that say it's about 1 to 1.5 times, and it's not that much of a cost difference. I don't trust those, but I don't really think cost should be the determining factor. Oh, yeah, here you go.
There you go.
This is from Death Penalty Designs, actually. Yeah.
Look at this. Firing squad, total 34, 0 botched. Look at all of this. This is nasty. Look,
Yeah, I know.
electrocution, 84 botched. What do you mean botched? What happened?
Well, and sometimes they kill them, but it's a torture killing. Like we had one recently that was actually recounted in Death Penalty Desired, that I had to tone down a little bit. You know, the R-rated version had a more explicit execution that actually happened in Florida. It was the end of the executions by electrocution and death row in Florida by electrocution because they toasted somebody. He burned, flames shot out of his head, his skin. It was horrific. And he was screaming out loud as the electricity shot through him. It's a brute. And I actually, in the R-rated version, it was explicit. I toned that down in the PG version because I thought the method of execution was so brutal and harsh because the words, you know, it's powerful, but that's actually what happened. And that would be categorized as a botched execution. It's not supposed to result in burning alive and screaming suffering. Like even in Lethal Injection, I mean, there was actually a, I think it was in Death Penalty Debates, I talk about a botched lethal injection where it took hours and hours and hours for the person to die as they screamed and gurgled, and it's just horrific.
What?
Yeah, so
what? This is so bad.
So
Okay.
basically, if you're for the death penalty, if you want a fair, best execution method, it's firing squad. Even though I'm against it, I'm going to say, you know, help out my friends on the other side of the aisle with this one.
I'll tell you all, and I mean, I'm from a country where we abolished the death penalty about 40 years ago or so, and there's a lot of differences between the laws in our two countries, but regardless of that, Steve and I think kind of similarly, I think, but I'm very open to the differences between our two cultures. I've since I've become friends with so many people in the US via YouTube, and got to know some more about the laws and the Constitution of the US, especially the Second Amendment. Your right to bear arms is very different to anything over here. And I've become more open to that. I'm respectful of those differences, and I'm respectful of the different opinions regarding the death penalty. Myself, I'll say right now, I am very opposed to the death penalty and have been my whole life, really. I think it was around, I was only a little kid when it occurred to me that if we believe as mortals, as human beings, that it's wrong, it's so wrong to take the life of somebody else, then who are we to do the same thing? Like, who are we to then sink to the level of the person who did that and do it to someone else? So
well, and there's the death penalty debates lays out all the arguments on both sides, and there's public policy arguments. But the thing on death penalty designs, I was really happy with myself on the first chapter, which talks about the history of the death penalty throughout human history, and about how I think that the death penalty is incongruent with the constitutional republic having its enlightenment source of we the people. Because historically, the death penalty has been imposed throughout human history, all of recorded history, but basically as a means of fear and oppression against people to subjugate them. And the concept of we the people, we left in slavery, right? And we also left in the death penalty. But I think both those concepts are incongruent with a constitutional republic based on consent of the governed and the rule of law by the people. I'd also say that was it on that topic? I don't know. I love. There's another point on that point because that I was kind of human history is a lot longer than just the United States, or a lot longer than just the English history. It's, world history. And so we're really coming to grasp. I think it is most civilized countries have done away with the death penalty for a number of reasons. And I would like to be in that camp ourselves. But, I know what I was going to say, that historically in the United States, there was a big death penalty abolition movement that was gaining traction. And most states were doing away with the death penalty until the states put it behind closed doors and stopped doing public executions. Once they stopped doing public executions, the death penalty abolitionist movement went away. And that's interesting. So, a lot of people say that I think we should have more death penalties, and they should be public and they should be televised. Well, as an anti-death penalty advocate, I'm for it, because that's what generated the anti-death penalty movement in the United States. And only by putting it behind closed doors did the state preserve that option.
Isn't that interesting? It's like out of sight, out of mind. You don't have to see the nasty stuff that's going on, and so suddenly it's not that big of a deal anymore, is it? It's kind of like,
because we don't see it. It's like, I don't want to see the dirtiest. I don't want to see the sausage getting made, right? Yeah.
Exactly. I don't know if you were following. Well, obviously you've been very busy with your new job, but just recently, the Richard Allen case. He was kept in solitary confinement for 13 months, and he was fed a drug called Haldol, which sends you psychotic, basically, melts your brain, and absolutely tortured, until the point where he would say and do anything. And he did. He confessed to the murders of two little girls. And I know that you know a fair bit about false confessions. And honestly, the fact that that is kept away, we can't see that stuff happen, right? And how many more of him are there?
Yeah, the people don't realize, and the confessions are powerful. Juries are it's very hard to convince juries that people falsely confess. But false confessions make up for about over 20% of actual innocent people who are convicted. People will falsely confess for a number of reasons. And people, actually, the most painful case of my life was a false confession case. And if you read Death Penalty Desired, the evil book out there that's that is a false confession case. That is a false confession case. And that you'll see the interaction between that is based on that case that I saw that was a false confession. And I interviewed a fellow named Professor DeClue, Dr. DeClue, who is one of the premier experts in false confessions on my Rubble channel. It goes a ways back. But yeah, the Innocence Project, see Shane has got here. Innocence Project lays out reasons for false convictions or wrongful convictions of innocent people. And I think every prosecutor needs to read all that, because when they get that confession, boy, it's game over. That person's guilty, they confessed. But you've got to be very skeptical and very careful with evidence as it comes forward. And that's sadly,
you think prosecutors care?
It depends on the jurisdiction.
Yeah. They've got their confession. You think they're not going to use it? Yeah.
Hey,
all right.
I see Danielle. Danielle's in the chat. Danielle and I were at the mosh pit at the Knocked Loose concert. So I got Danielle. Yeah, we went to Orlando. My son wanted to see a band called Knocked Loose, which is a hardcore heavy metal punk band, and they've got the mosh pits. They've got some of the most violent mosh pits out there. And so, I saw Danielle came to in Orlando, and I got her to come in the mosh pit. It was like the best thing, and it was a great show. Knocked Loose was a great band. So, anyways, hi Danielle.
Hey Danielle, how's it
all
going?
My videos, by the way, Danielle, all my videos came out terrible. They're all just unusable because they're just all noise.
I see some people talking about Laken, what's her surname? Sorry, Laken Riley, in the chat, and her attacker, her murderer, has been found guilty, life without parole. There's a lot of anger towards him right now, and people are calling for the death penalty for him.
Well, but it's just that the death penalty. Well, and I've only got about 10 more minutes here, so get your
I
questions
know.
in if you want. But
Yeah.
I've got to have dinner and stuff. But
Yes.
the thing about like this case, this Kohberger multi-murder case, right,
Yeah.
is a horrific case. It's a horrific case. And so somebody it challenges somebody who's an anti-death penalty person like myself. Facts like this challenge me. And people will say, I'm morally superior to you because I'm for the death penalty for this guy. Look at these facts. All right. And I agree, these facts are the worst of the worst. And I think if he's guilty, the maximum penalty should be imposed. The maximum penalty in my book is life in prison without the possibility of parole. That is the maximum penalty in my book. Now, why do I discount the death penalty other than religious reasons for somebody like that? Because it's a system. And the system that allows for the death penalty on some fact pattern like this, which is horrific, also allows the death penalty in cases of actual innocence that are wrongful convictions. So the choice is not between executing this guy and letting the innocent people go free, right? You buy into a system that allows the death penalty in the worst of the worst and against actually innocent people, or a failure rate where innocent people will be killed, or you eliminate the death penalty on both. So I have to be willing to grant mercy to Mr. Kohberger and allow this bleeding heart in me to give him life in prison without parole, right? That softy sentence of Gosney, in order to preserve the life of the actual innocent person who may be exonerated in 30 years.
Yep.
Okay, I would rather err on the side of life than allow the death penalty against the evil guy here, but also allow the death penalty to be imposed against national innocence. And that is the choice. It's a system that you support. It's not the individual case. So if you're interested in this debate, get death penalty debates.
Yeah, 100% agree. You can't just go, okay, well, this particular person is so evil, so now let's death penalty for that person. That means that just about anybody could end up in that same situation, someone who's innocent.
And we have, and look at somebody like Solomon Anderson,
Yeah.
that case could have been a death penalty case, but he's in life in prison. And you've got an actually innocent person, I think.
He's innocent.
Who
Yep.
who is now, and because you got a rogue prosecutor and a judge who's a little dippy, and all of a sudden you get throw people away. Yeah, Solomon, I pray for you and your brother.
Yep, absolutely. We think about you all the time. And by the way, looking forward to hearing when the appeal comes up. Solomon, if you're still in chat, let us know when approximately that's happening, because Andrea has said she's interested in knowing about the appeal. She wants to review it, at least do a stream on it. So that would be fantastic. And I'm sure that you would be willing to talk about that too, Steve.
Oh yeah, I think MLS is doing a video, and I
Yes.
appeared. I did some quotes for the video. So it's such a tough case. I know he's got excellent appellate counsel, but boy, I'll tell you,
Yes.
a rogue prosecutor and a bad judge can convict the innocent, and that is a lot more common than we realize. And that's one of the reasons I'm against the death penalty, right? Because those people exist. Those people infect the system.
Yes. Yeah, we're talking about Zachariah Anderson. Absolutely. Yes. He was absolutely railroaded. All right, that's it. Thank you so much, Steve. You have been just a joy as always. Absolutely. Your mind is a treasure trove of information, and I just love having you around. We all do. It's so nice to have you back a little bit, although you are working really, really long hours and things. So don't get too used to Steve being on the YouTubes. He's working long hours and stuff. But definitely have a look at his new book. It's pinned to the top of chat. Death Penalty Design.
And this is only for the law nerds. Okay, if you're really into the death penalty, you want to understand all these legal arguments that we talked about tonight, this is your book. Now, if you want an exciting crime novel, it's Death Penalty Desired. If you want a public policy debate, it's Death Penalty Debates. Those three books work together if you're a death penalty person, and that's what we're talking about tonight. They're all available on Amazon, so go get them.
Yeah,
or my
wonderful
website.
Oh yeah, well we've put your website up there, so everyone can have a look at all of them, including Brucey, the One-Eyed Wonder Dog, which is lovely.
Brucey is sold out.
Brucey's sold out.
The coloring book is still available.
You need to get more Bruceys.
I'm working on it. I'm gonna. It's a project. It's a complicated issue, but I'm working on it.
All right. You're always welcome here anytime. All
right. Thank you.
And thank you so much. We adore Steve. Thank you. And what we're going to do is I'm going to dump you guys into Nick Starrow's waiting room, into his chat, because he's having a Saturday night stream shortly. Also, the other thing that's happening is David is having a Lego stream too. So I think is that considered 9 p.m.? It's in half an hour anyway. Half an hour. Yep. So whatever that is Eastern time, I don't know. Whatever. For me, it's 11:30 a.m. on Sunday. So go figure. I'll see you guys. 9 p.m.
All right.
Yes, Lego stream. Cool. Thank you guys so much. Time for the song. We have to do the song, everybody. Do. Where is it? I've always got to find it. Oh, there we go.
Her name was Helen. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud and because she's an 803. To the attention, excited utterance. Her cat